Welcome to Looking at Legal Stuff. Today we have 7 hearings in a case with a conservative couple where mom is filing for divorce after 20 years of marriage. She says dad has been cheating on her with a woman from their homeschooling co op. Attorney Baldwin claims that not only has dad been financially controlling, but he's also been extremely controlling over the children and their educations. She claims that dad has insisted on homeschooling the children himself the past few years, despite the fact that he still works full time. She claims that standardized testing has shown that the children are years behind. She also claims that dad has been exposing the children to his mistress at youth group and their homeschooling co op, and she wants this woman banned from being around the children anymore. What does dad have to say about these accusations? Let's find out.
Baldwin, I represent Annie. Amy Yin she's the mother and primary parent of the 3 children in this action, age 16, 13, and 12. First off, I did file an objection to the declaration filed in this case by the petitioner, largely due to page 3. About 3/4 of that page is just pretty unadulterated hearsay. So I'd ask the court not to consider that. This is our motion for temporary orders. We're agreed to set over the financial issues for an additional 2 weeks because this was put in on shortened time. But we're asking the court today to establish a school plan for the children. That's most important. The children have been doing homeschooling, and there's a debate on whether or not that should continue. We need the court today to make decisions about the family home and who should move out, and then at least a minimum of an interim parenting plan so that there's not chaos between sort of today and when we get to a more fleshed out parenting plan. I understand the court may set the broad strokes on the plan today and sort of put finer points on it in 2 weeks.
I'm going to pause 1 second, Ms. Baldwin. So family home, at least the bare bones of a parenting plan, and the school.
Yep.
Okay.
And that'll leave and I believe Ms. Bliss agrees. She's nodding her head in agreement.
Yeah, that's agreed.
Okay. So with that, I do think it's important that the court, in this case, consider the cultural context for these children. It's relevant that this was an extremely conservative religious family, and that matters in the context of the children's overall needs and their best interest when you take in sort of the overall perspective of this family. My client has been a stay-at-home mother for about 16 years. During that time period, she sacrificed herself for education, her career. She stayed at home with the children, educated them, coached them, did programs. If you look at posts from Mr. that he had posted on social media in 2022 and 2023, he talks about this, that mother sacrificed. She sacrificed for her children, that she's a wonderful and involved parent and coach to them. And they're not sort of just, a single one-off. They're long posts where he talks about sort of all of my clients' involvement. And really that comes down to my client has historically and currently managed the parenting functions for these children. To Mr.'s credit, he worked and advanced his career to benefit the children in the community financially. My client stayed when she was a stay-at-home parent. She also did what was called Friday Co-op School, which is a slightly more formal co-op homeschooling group. My client sort of details some of the specifics of that group. Around 2017, my client began working at Three Rivers Christian School. The children ended up being enrolled there around that time to be close to her, so she would continue to essentially manage them while she was working. 2017 to 2020, we have the kids sort of in a combination of both private school and public school. The pandemic, unfortunately, happens in 2020. Kids end up being homeschooled. There wasn't a lot of options during that time period, as most schools were remote. In 2021, we see River and Shiloh doing, which are the 2 younger children doing homeschool, while Evangeline, who is the older child, doing a combination of public and private school during that year. Essentially in 2021 and 2022, we see that Mr.'s largely sort of in control or managing the homeschooling environment, while my client is then at that point working full time. And to be clear, he's also working full time. So we have 2 full-time working parents. It's just that Mr. said, well, I'm working from home, so I'm going to manage all the school things. In 2022, we see Mr.'s continuing to work his full-time demanding job, but the children curiously stopped attending the Friday co-op school that they had historically attended. We see then the children start attending a new co-op with a person named Maggie Kennedy, who ends up being Mr.'s girlfriend. And Mrs. Kennedy's co-op, Mr. Even calls it to my client, tells about how it's chaotic, how the children are used to really just babysit other children. So he's got his own complaints about this, but still continues forward with this co-op that's not well run and not well managed, and even if it wasn't really working. Around this time, Mr. starts setting Alexa sort of computer indications to set verbal reminders for the children to do their work independently without him really being significantly involved in their work. By 2022 and into the 2023 school year, my client's increasingly concerned. We don't see any completion of any sort of programs, and we don't see anything in the court file. We don't see any formal or informal sort of work or programs for the children, and we see a refusal to engage the children in required formal testing. And I would argue that that's sort of critical because this is testing that's supposed to be done to make sure children who are homeschooled are staying on track. I think Mr. knew that they were nowhere near on track, and so didn't do this testing, so that the fact that the children were failing wasn't formally known by anyone. You could sort of just cover the fact that the children weren't actually doing anything and just say, oh yeah, they're fine. But because there's no testing, there was sort of no benchmark to say they're not fine, they're failing. This comes to a head. My clients again gets concerned. She says, hey, there's no work, there's no testing, there's no progress. You're leaving the sort of semi-quality of this one co-op to join this other one. And at that point, she didn't understand that Ms. Kennedy was the girlfriend. So doesn't understand why you're continuing to engage this co-op that you call chaotic and where the kids are being babysat. And that's unfortunately where later my client finds out that there was an affair that was happening with Ms. Kennedy. And while this is a no-fault state and you're free to do that and you're free to move on, what you aren't free to do is involve your kids in your affair. We all know that that's directly damaging to children, to involve them, to make them part of this. And that's why these children's culture is really relevant here. This is a very conservative Christian home, and Mr. engaging in this behavior is far outside these folks' norm and more damaging to these children than to other children that don't have this type of underlying culture. And the concern here is that Mr.'s priority is really seeing Mrs. Kennedy and not the children's academic progress. And he doesn't deny in his declaration that Ms. Kennedy is a high priority for him, that she's the one that's running the co-op, that he's having an affair. We don't really see him denying any of that. What we do see is his plan to continue what's happening. He says, I want to continue homeschooling the children, continue what I've been doing, even though the children are terribly failing in every rubric, regardless of whose numbers you look at. These children are ages behind where they should be. It's clear that for him, his priority is really the girlfriend, and that's to the children's detriment. When you look at the formal testing that my client had done, and my client notes he was enraged that she did this, that she had the audacity to sort of step out of his control and have this done. We have an 11th grader who's academically 5 to 6 grade levels behind. That means I have an 11th grader who is somewhere around 5th and 6th grade levels. We have a 9th grader who is at 4th grade in math and at the 4th percentile for sentence comprehension. That means they're at 3 out of 100 children are worse than that child at sentence comprehension. And we have a 7th grader who is testing at 2nd grade math and 5th grade reading. And these are just some of the scores, but the other scores are in line with this, meaning that we have children that are wildly behind. They haven't been homeschooled, they've been unschooled, meaning that they've just been sort of allowed to ravage on their own for 2 years and not really do anything. And you see that by not only the fact that they're testing behind, but you see regression from where they were, because if you don't do anything academically for years on end, you're going to regress. That's just the reality of it. And that's what happens when you're using Alexa to teach your kids. That's not appropriate. And this is what Mr. wants to continue doing. It's not appropriate. It's not in their best interest. So what do? We now have 3 children that are very behind, that need to get into formal education and frankly need to catch up in education. My client proposes that the oldest 2, Evangeline and River, attend Mark Morris. Both of those children already have social contacts at Mark Morris, and both have already been involved in sports programs that are around Mark Morris. So they know those children, they've been involved in some of the Mark Morris programs, and Mark Morris is best situated to catch those children up. And I'll give them sort of not only academic support, but social support as well, which is hard for kids. The other child, Shiloh, who's the younger child or youngest child of these 3, my client proposes that child attend Three Rivers Christian School. That child has social contacts at that school. And that child also has a history at that school. So that allows that child to have the same sort of social buffer and comfort level with the school that child would be attending. And that formal education will also allow that child to catch up to appropriate levels. A continuance of homeschool would absolutely be a clear detriment. And I think it's important that we consider sort of some of the dynamics of power and control that we see in this case. We see Mr. saying, not only do I want to continue the system that we know is failing, but I would argue he does so to keep those children within his control, within his power to be able to sort of use that. We see financial control of my client, where she talks about how she's only given an allowance, name calling and gaslighting, Mr. sort of using the phones and cell phones to stalk my client, learn her locations, him being enraged that the children were tested without his approval. And I would argue that's because all of a sudden the light is being shined on sort of his actions. And my client talks about hidden financial accounts that she can see but has no access to and no knowledge of, sort of transfers out of their account to places that she doesn't even know what's going on with those things. So when you look at sort of the context of that power and control and that dynamic, I think it raises a lot of red flags. In the interim, we're asking the court to make my client the primary parent. She's historically been so. She is the primary parent now. It's most appropriate. On an interim basis, mom should be primary. We'd ask that Mr. have at least Friday to Sunday every other weekend. Again, we're only here, we're going to be back here in 2 weeks is our proposal. So this is not a long-term solution. But that at least sort of gets us a reasonable some sort of visitation between now and 2 weeks. But we do have to have something in place. Otherwise, this unfortunately will devolve to chaos. There also should be a limit on disparaging, talking about the legal matters, telling children people's diagnoses or your perceptions of those. None of that is appropriate or reasonable. The next issue the court has to decide is the family home. Again, we're asking the court to find my client as the primary parent because there's a long history of that. Children and family home should go together. That's logical. The children should not be disrupted or have the least amount of disruption at this point. My client does not have the financial means to move out. If you look at the financial declarations, my client has about $1,700 a month net versus Mr. at over $11,000 net. There's a huge disparity there. My client does not have the financial ability to move out. Similarly, my client does not have free, readily accessible housing. Sort of Mr. claims, oh, she could just move into some family's home. That's not realistic. That's not possible. In contrast, Mr. does have the financial capability to go rent an apartment for himself. He has family nearby that he has resided with and can do so again. And then my client notes that on a preservation of the community asset context, Mr. has failed to pay the mortgage. He's had all the financial control in this case. But when my client actually looked at the mortgage, she says, oh, there's 12 late payments in the last 12 months. So he's not paying the mortgage on time. And in fact, the mortgage is currently behind 2.5 months. And I would argue that was tactical, that was not a slip of the mind, but tactical in knowing that he had filed this divorce, that stop paying the mortgage comes closely in line with when he filed this dissolution. And the idea being that, well, I'll just stop paying the mortgage. I'll put that money in my pocket. And that way, if I have to leave the house, I've got this financial cushion. So I'd argue that that's tactical, but it also shows he can't be trusted to preserve the community asset. So given this, we're asking that my client the court award possession of the home to my client. Mr. should move out by Friday. He's currently still living there. He can take his personal effects, personal clothing, all of those things, anything that's agreed. We'd ask that any other major move outs wait, either until we have an agreement and Ms. Bliss and I can work on that, or until trial. But we shouldn't have sort of a free-for-all with a moving truck is what we want to avoid. So again, we're asking the court to make my client primary parent, award alternating weekends to Mr. That should start not this weekend, but next weekend. The idea being he's not moving out till Friday. That gives him a week to get settled before the kids would be with him. No disparagement. Oldest 2 children to Mark Morris, the youngest child to Three Rivers Christian School. Again, award the home to my client with Mr. moving out by Friday.
Thank you. Ms. Bliss.
And Your Honor, as you can tell by the file, I'm newly on this case. I entered my notice of appearance, I believe, on Thursday or Friday of last week, along with my client's declaration. I was retained late last week, got to this as fast as I could, knowing that we were before the court today on 2 minimal issues. I will just note that the tail end of counsel's argument got a lot into the financials, which obviously my client hasn't had the opportunity to formulate a response for, so I would just kindly remind the court of that. The issues before the court today are where the children are going to attend school, who's going to remain in the family home, which arguably could also wait 2 weeks until we address all of the financial issues and can provide more argument, but nevertheless, and an interim parenting plan. What's interesting in this case is the timeline. Counsel argues that mother is the primary parent, that she has provided all parenting functions. Yet in her discussions, that timeline stopped as of 2017 when she began working. My client provides for the court that arguably prior to the pandemic, but most certainly once the pandemic began, he began taking on all of those responsibilities as he was home from work and could attend to the children's needs. My client provides that early on in the pandemic, the children were all in public or private school, excuse me. What's interesting is the oldest child, Evangeline, was only homeschooled for 5 months. So if Your Honor looks at the timeline of events on that, both Ms. Yanez and my client both acknowledge the fact that she attended Three Rivers Christian, also attended a public school, and then ultimately went to homeschooling. So the largest argument is these assessments of these children. What's concerning is the minimal amount of time my client has actually homeschooled these children and how far behind they are in school. That goes toe in toe with my client's allegation that testing in the middle of summer is simply inappropriate. Most of the time in public schooling, standardized testing is during the school year because that's when the children are actually learning these topics, not 2 months, 3 months into summer, where no children in this case have picked up books, have studied, because that's what summer is for. So my client raised significant concerns with mother having these children tested without having any forewarning, without having any pre-testing, or frankly, during the school year when the children's brains are actively involved in learning. My client provides to the court several discussions regarding getting the children tested this past spring. Due to the family being out of town, that wasn't available. He indicates that he has scheduled testing with that administrator for the fall. So to simply state that my client was trying to hide that he wasn't providing any sort of schooling for these children is absolutely discredited by these statements in and of themselves. Next, looking to, and largely the biggest issue is this allegation of my client having a girlfriend. He adamantly denies that. Again, had we had more than a day to formulate a response, further evidence could have been provided to counteract that allegation of Mrs. Nevertheless, it's irrelevant. My client denies any allegations that he was spending time with his girlfriend instead of teaching the children. He specifically states in his declaration that Alexa is essentially a bell in between classes, that she wasn't used to teach the classes, that she was used to keep them on track for which subjects they were learning together. My client goes in depth into the different programs that he looked into, the curriculum, different learning styles for Shiloh in particular, telling the court that this last year, towards the tail end of the year, was the most growth he had seen with her. My client is simply asking the court to maintain status quo at this time. The children are doing well in their homeschooling ventures. My client provides that there are various co-ops that they're a part of to help their social growth. That they're constantly engaged in band and choir and volleyball and all of these different programs to keep them actively engaged. What's concerning is Mrs. Rush into this without having all of the information provided, despite my request of newly being retained to set this matter over. That was denied, and she demanded we move forward today, without having a guardian ad litem appointed to investigate all of the allegations that are being brought forth by mother, without the court having full information as to the actual ins and outs of this relationship. To make a drastic change on essentially a one-sided allegation with zero documentation to support it. All of these allegations of Alexa teaching the children, there's no firsthand knowledge of that. There's no documentation provided to the court to substantiate that claim. It's mother essentially creating her narrative to get the court to rule what she's wanting, in contrary to what's in the children's best interest. What's in the children's best interest is to maintain their status quo. Obviously, divorcing parents are difficult for any child, let alone a child in this family, in this very conservative cultural upbringing. Disrupting that on top of disrupting their school, forcing them to go back into schools where they obviously weren't performing well. Again, the timeline of issues of these children being 4, 5, 6 grades behind, that does not happen in 1 year. So there's a lot of concerns there as well that my client has articulated to the court in his declaration. We simply cannot make these drastic decisions on this short of notice. The court needs to have full information, whether that's additional testing, whether that's continuing the school to show that, and my client is more than happy to provide the court his curriculum for the children in that regard. However, again, with minimal timeline, we didn't have that opportunity. So I would ask the court to maintain status quo at this juncture. Obviously, a guardian ad litem is necessary in this case to determine what long-term is going to be appropriate for these children, but the least disruption in their lives is obviously in their best interest at this point. Looking next to the home, obviously that goes hand in hand. My client works remotely. He works from home, as do the children attend school from home. My client provides that it's more efficient, at least at this juncture, again, not getting into the financials because that's not what we're before the court on today, but Mrs. has the opportunity and the ability, my client provides in his declaration, her grandfather's home, whom she's gone to during periods of their separation, has 3 vacant bedrooms, enough room for her and the children, whereas my client has zero opportunity. There's a lot of discussion of, well, he was the breadwinner, he's got more financial ability. However, at this short of time, and we're not even discussing financial status, having him pay 100% of the community bills, which is mother's request, and going out and getting his own place while this case is still pending and no formal decisions have actually been made on that, is setting all of these parties up for failure. Mother has the ability to, and I would argue, since we are setting this matter over 2 weeks, that the issue of remaining in the home just be reserved pending that time so that the court does have full information, allowing all of the parties, unfortunately, to remain in the home, which may not be the best given the statute or the status, but I think that might be easier for the court to ascertain what is appropriate long-term. But making rash decisions without the full story, without the full documentation or evidence or anything to substantiate anybody's allegations, I think is setting all of these parties up for failure. My client is asking the court to essentially maintain status quo all around, that the children remain in homeschooling, whereas he is their teacher. There's no objection to limiting. I know there's a lot of allegations about him having a girlfriend, despite the fact that he denies all of those allegations. There's no objection to prohibiting any sort of contact with that, or any sort of contact with any third parties or romantic interests in the future, if that be the case. But as of right now, the least disruption that these children have to be exposed to is obviously paramount to their success moving forward. My client argues that maintaining status quo with the schooling and maintaining him in the home, as like I said, he's employed and works remotely and teaches the children from home. That is in everybody's best interest. With that, I would argue that there doesn't need to be a decision on the parenting plan today if the court orders that all of the parties remain in the home pending the 2 week set over. If Your Honor wants to make a determination as to a parenting plan, again, I would just ask that that be reserved, as my client was under the impression at the time of his declaration that the only issues were who were remaining in the home and where the children would be attending school.
So who's living in the family home currently?
They both
All
are.
of them.
Everybody is.
Yes.
And, okay. And then, okay. All right. Ms. Baldwin, go ahead.
Thank you.
Thank you, Ms. Bliss.
So first of all, we did not agree to a continuance of all issues, frankly, for the children's best interest. School starts next week. The worst thing you can do to two teenagers and one preteen is to make them come to public school or private school a weekend to school. That's awful. And so based on, frankly, solely the children's best interest, we said no, because that issue it really has to be decided today in the children's best interest. The Mr. statements that he didn't have time to respond. We're limited to 6 pages, double space type. Mr. spent 5 pages answering where the kids should go to school. He has answered. He has answered fully that question. He has used 5 of his 6 total pages to answer that question. Arguably, he should only be granted a single page to answer all of the financials. I'm not asking the court to hold to that, but this idea that, well, if I had had more time, like, you spent 5 pages answering this question. You have answered. You've put all the information before the court that the court needs. The reality here is it comes down to that testing. He wants to continue a system that has absolutely failed in every measure. And he can't show a lick of anything that shows otherwise. These statements of like, oh, well, gee, we're on vacation in the spring, so we can get them tested. That's ludicrous. You had a year to have them tested. You could have done it at any time. It's the same when people said I was sick for a day and that's why I didn't, respond to my case. It's like, well, that was one day. What did you do for the other 6 months? So again, that's sort of a ludicrous statement to bring to the court. Again, Mr. admits he works full time. He's not educating them during the day. He can't. He's working full time. So this idea that he can be a full-time teacher and go to work full time just doesn't make sense. And it isn't working. And we know that objectively. We have an objective measure. This is not he said, she said. We have an objective rubric that these kids are wildly behind where they need to be. And that what has happened the last 2 years has not worked and is not working. I do agree that we do need a guardian ad litem in this matter. That's more than appropriate. The court can give us the list, or Ms. Bliss and I can ask the clerk for it via email later today. Again, counsel sort of says, oh, he looked into programs. He didn't do them, obviously. These kids are, again, wildly behind, no proof that they've done anything academically, that he could have click, print. If they had testing that he had done internally to whatever program they were using, none of that exists. And he could have easily produced that. So again, what we're doing now has not worked and has been an obvious detriment to these children. Waiting to make this decision is a detriment to these children. We have to make this decision today. And because we have the objective testing, we have the ability to make that decision clearly and definitive way today. As far as everyone remaining in the family home, that is just begging for a breach of the peace. And that's not appropriate, especially in cases where you have power and control issues. That's not appropriate. I agree that a final parenting plan can wait, but when the court decides, who's going to stay in the family home, we should set that for the next 2 weeks. Here's what parents' time is going to look like, because that's reasonable to these kids and fair to the children of this action. So again, we're asking the 2 oldest children to attend Mark Morris, the youngest child to attend TRCS. That's appropriate with their educational needs and their social, emotional needs of these children, that my client remain in the family home. And the court established essentially my client is primary and set some sort of visitation for Mr. And we hold the rest of the financial issues for 2 weeks.
One further question to either party. So 2017, Mrs. went back to work, but children didn't start full-time homeschooling until COVID-ish.
Yeah.
Or was it right before or around COVID?
I think
Okay.
it was right around COVID.
Okay.
Mhm.
Okay. Well, clearly there's a lot of issues in this case and a lot of concerns, and I've reviewed all the documentation that's been provided by the parties. I know we're not into finances, but clearly there's a pretty major gap in the earnings of the two parties, just in the preliminary information that's been provided to the court. So first and foremost, I'm going to have, it appears to be established that the two older students have already been participating in extracurricular activities through the public school system, and participated in, forgive me, I think it was volleyball and something else over the summertime through Mark Morris High School, or through the Longview School District by way of Mark Morris High School. And the youngest has previously attended Three Rivers Christian School as well. And so there's already strains of friendships and knowledge that kind of weave in and out of the school systems that we have, and additionally to the different programs, the homeschool programs that have been in place as well. I'm gonna order they be enrolled in Mark Morris, the two older, and the youngest at Three Rivers Christian School. And frankly, I'm doing that because it's easier to do that now. And if it changes in 2 weeks, they're at least, I don't think going back to homeschooling is going to be that big of a shock to them. And I think so. I'd rather prepare them, have them get registered and ready to go for those two schools for all three children. So that's that. Given the disparity in finances, and so just to confirm, in the interim, given the disparity in incomes, I'm going to have mom remain in the home. Dad has the ability to get something on a temporary basis. So I'm going to ask that he be removed from the home until further court order. Children remain in the primary home with mom. Dad, granted, not knowing, I don't know if he has a plan or if there is something available to him, but he should get the next 2 weekends. So we'll do this Friday at noon until Sunday at 6. Next Friday, does school start next week? So it's Friday after school until Sunday at 6. That should get us into our next hearing, which we will set for September 5th at 1 p.m. They should also allow to contact, so phone calls, if any of the kids want to contact the other parent, they should be free to do that. No disparaging comments about this case, the other parent. Anything should be shared with the children at this point in time. I do anticipate this is probably a case where we will need a guardian ad litem, so we will address that next week, unless the parties want to get that.
We can
get someone onboarded now.
As well.
That's fine.
Do we have the next 3 names from Madam Clerk, please? Ms.
Ms. Bliss, go ahead.
Yeah, Ms. Bliss.
I guess I would just strike the first name is Kale.
I don't really have a preference between the next two, so I'll strike Ms. Height just so that it goes to the next one. So that'd be Ms. Turnbull.
All right, Ms. Turnbull will be appointed as a guardian ad litem. If we could have that for presentation on the 5th, that would be awesome.
Yes.
And then I think that's the triage that'll get us to the 5th.
And then your Honor's order was that he move out immediately.
I don't know how precarious the situation is. I don't want him to not have what he needs in order to continue working so I think
I propose Friday. That gives him.
I think that's fair. And I don't want it to be a rush job, but it's also, it may be temporary. So, but I want him the opportunity to get what he needs and what he needs to continue to work from home, away from home. And that leaves us with Yanez and Yanez 23300278808.
That matter's ready.
And I have, let's see. Let's go through the order first, because I think
I unmuted you.
that was nice.
So let's see. I'm the moving party. So there should be declarations of my client as the moving party, Ms. Bliss's client regarding mostly the school issues and parenting plan, a reply by my client, then a kind of a reply to the whole by Ms. Bliss's client, and then a response by my client that was sent Friday. And that would be, I think, and Ms. Bliss can correct me, but I think that's sort of the different documents that have been filed.
And then we have
Yes,
the order.
Oh, and the order, yes.
So that I was going to just say, let's start with the order so we can get
Okay.
that out of the way.
Fair enough.
So I have, hold on. I have the order appointing the guardian ad litem. I think
the only issue I had with that was the fees, depending on whatever your honor does with the child support worksheets, and then setting an interim review. Obviously, your honor made a temporary ruling as to the schooling, and that was a big concern that my client had and wanted that addressed sooner rather than later. I simply suggested either a 30 or 45-day interim review.
And I don't think every case needs an interim review. I don't think that that's reasonable to the guardian ad litems, or frankly necessary in this case. I think the court did what it did as a Band-Aid for temporary orders, but not to then cause these parties to have yet another review in 30 days where there's sort of this idea that we're going to upend the apple cart yet again, type of thing. So I'd ask that we not send an interim review. And as far as the incomes, regardless, Mr. makes 3 times what my client makes. I think the amounts that I sort of just put as placeholders are reasonable. You can always adjust it at final.
okay. That was under section
Uh,
6 on the GAL that you were requesting the interim review.
That was section 6.
Okay. First, I did note that the deadline is January 15th, 2023. So did you mean 2024?
I did,
Yes.
thank you.
Okay. So I'm going to make that change. As to a review date to see about changing schedules, I'm not inclined to do that at this point in time. If there is any concerns or something that arises, then obviously that can be brought before the court, but otherwise I'm not just going to set a review for school. I think the information that I recall reading thus far is that they're excited, engaged, already enrolled in, or not enrolled, but engaged in extracurricular activities. So I'm going to sign the GAL order as is. Miss Bliss, are you okay with me saying approved via Zoom?
Yeah, that's fine.
All right, and then as to the order on hearing, there was an objection, or not an objection, a request for non-residential parent having liberal telephone contact under section 4C. Any response, Ms. Baldwin?
Only that this is an interim order, and I essentially put kids can call both parents if they wanted it to be her client. I don't think that's a necessary change.
I guess my concern is this order is limiting to only the children being able to initiate phone contact. I understand it's only an interim order, and depending on what your honor does today, we'll have a formal parenting plan order in place. So I'll defer to the court as to that.
Yeah, same.
Okay, so I just added non-residential parent may contact children. Via phone. I couldn't read my own handwriting for a second. That's not good. Via phone, but shall not unduly interfere with the other parent's time.
Okay.
That's fine.
Then in 4E, temporary possession pending further hearing, and then petitioner shall be permitted to retrieve additional belongings. Any response to that, Ms. Baldwin?
I don't really have any objection. I think everybody understood this was an interim order until we got to today, so.
And I believe in the, your client's response, she indicated as long as there was notice, she was fine with him getting more of his belongings, so.
So long as he's not just entering the home,
Right.
he needs to make a date and time, and arrange for pickup.
Okay, so what I've just added, I said Amy Yanez shall have temporary possession of the address. Petitioner shall vacate by that date and time. Petitioner shall be permitted to retrieve additional belongings with notice and at an agreed upon date and time. All right, and I'll sign that. Okay to indicate approved via Zoom, Ms. Bliss?
Yes, Your Honor.
All right. All right, now let's move on to the other. Thank you.
And so similar to this one, Ms. Bliss, or similar to the last case we handled, Ms. Bliss's client, this kind of got before the court in a little bit different structure, just because we were here in short time addressing some issues and then came back today. Did the court have an opportunity to receive my client's reply? It sounds like you did based on what you said.
I did, yes. I think I received a hard copy, and I want to think that it was also made it into ODYSSEY. So yes.
Very good. All right. So at this point, and this is my client's motion for temporary orders. This is a 20-year marriage. This is not a short-term marriage. This is a long-term marriage. There are 3 children, all sort of the teenage type ages, from young teens to sort of older teens, that we have to deal with as far as parenting plan. My client has been the primary parent of these children. She was the stay-at-home parent for 16 years. The vast majority of these children's lives are with my client being at home, either being a full-time parent at home, or as well as being their educator at home. It's only been in the last few years that the children went into sort of formal schooling. They started through Rivers Christian School, but at that time, my client was also working there. So again, you see that sort of mom and kids are at the same place, the same time. Mom's off in the summer, they're off in the summer. So again, my client sort of sacrificing being the parent that is primarily responsible for them and their needs, and being essentially 100% available to the children at all times. This really only changed in the pandemic. At that point, the children then went from Rivers Christian School to then they transferred to doing some homeschooling. Mr. at that time was doing schooling with them at home, or at least that was the claim. And the concern here, and my client continued to work through Rivers Christian, as well as going back to school, trying to sort of get an education so she could better herself reasonably. But when we look at what's happened with the children's education for the last 2 years or so with Mr., it's gone terribly. And there's really no other statement here. There's no evidence that Mr. engaged them in required state testing to ensure that they were learning and meeting benchmarks. He doesn't provide any of that to you. So there's the indication is that when it's lacking, it means it didn't happen. He didn't have them tested. And the concern when parents do that is it means they don't want to be tracked. They don't want to have any kind of oversight on what they're doing. So it's not actually doing the job entailed. And how do we know he's not really doing that job as far as educating his children? Well, number one, he's working full time. So this idea that you're going to work full time and teaching is kind of your side gig that you're doing literally on the side of work doesn't make a lot of sense. It just logically is inconsistent. Second, with all the materials, and now he has had extra time to produce them, there is not a shred of evidence he did anything for those years. There's not a single assignment these kids turned in. There is not a single curriculum he produces. There isn't a single test he can show you, not a scribbled notebook sheet of paper, literally nothing. And that is what is, I think, devastating for these children is they've been unschooled. It's not that he has homeschooled them, he has unschooled them, meaning to essentially strip education away from them. So again, when we have the actual testing, these kids are 5 to 6 years behind now. This is not, not 6 months. This is not sort of the summer leg. This is kids who have actively regressed from their time in formal schooling. And that is a deep concern. And Mr., when you think about his priorities and what he's asking you to do, he wants to return to that. That is his stated plan for these children is I want to keep doing that system, the same system and keep going to the same co-op that my client says that's really his girlfriend and that's his priority. That is his focus. And that's why he wants to return to there, because even though the testing shows this has failed, he just says, I'm going to turn a blind eye to that, blind eye to the objective evidence and continue on because that's what I want. That's what he wants as a person, regardless of whether or not it's harming the children. And so that's the concern, is Mr.'s priority is really himself and his desires and not what is best for these with these young children. So again, in a situation where you can't even show a single assignment that these kids have completed essentially in 2 years. So again, priority for Mr. is his desires, not children's best interests. My client also talks about abusive use of conflict, and you really see that with the kids. So your court order last week is kids need to get into school, period, full stop, go get them enrolled. And you see an email from my office to Ms. Bliss's where it's like, man, Mr.'s already interfering. Can you please, we're just trying to get these kids enrolled and get this process going, and Mr.'s already interfering with that. Similarly, it's clear that the children have been made fully aware of the court process and fully, at least as to Mr.'s side, my client's getting the blowback of that emotionally from the children, them being extremely upset, calling my client, they're upset, they're calling her a liar, blaming her for things, because again, what they're hearing is not actually maybe what's the truth about what's happened here, but instead Mr.'s version. And so again, we have this parent who's interfering, who's involving the children directly and trying to sort of twist these children to do what he wants. And so again, a deep concern there. Similarly, my client reports that they had internal security cameras in their home that faced into the home, like the living rooms and those types of places. My client says it's accessible on an app. She knew that. He wasn't going to stop accessing it, so she unplugged all the cameras. Kid's going to visit with dad. Magically, all the cameras are plugged back in. My client's like, I didn't do that.
I'm going to have to object. All of this was provided on Mrs. Sir reply, giving my client zero opportunity to address any of these allegations.
Well, I'm not sure what he could address, if anything, on that one, other than he's just going to deny it. But my client, these are objective things.
It'll be noted. It'll all be weighted as well. Okay, go ahead.
So again, the concern here is that Mr.'s directly involved in the children, not only in the litigation, but sort of his attempts to continue to surveil my client. Thankfully, the reports are children are doing well at Mark Morris and at TRCS. They have social groups and social outlets already and connections there that they had built through various things. And so they're thankfully getting right back into the swing of things, but it's still going to be a challenge for them. The testing shows they are way behind. And that is going to take some heavy lifting on these children's part to catch up. And the idea that we're going to have some kids that are going through a very challenging time in their lives, and they're also academically going to be really struggling compared to their peers. I think that's something that we need to keep in mind on sort of how Mr. interferes with these children and how that is going to impact, again, their best interests long term. The domestic violence elements in this case shouldn't be ignored. Again, Mr. tracking my client via her cell phone and the kids' cell phones, the cameras in the home, the financial controls that my client talked about of him sort of providing her an allowance. And there's accounts she didn't even know about or didn't know how to access, and those were his. And she was kind of kept on this really very de minimis budget, all while we don't know where all the money is going, type of a thing. Very concerning. My client points to gaslighting as well as sort of love bombing, that she files this motion and then it's, I want to get back together, everything's hunky-dory. And again, the culture of these people for 20 plus years is a extremely conservative Christian couple. So again, my client doesn't want to be on this road. So it's sort of that, again, that gaslighting, that control. But the second my client says, no, the kids have to go to real school, I cannot neglect them that way, Mr. blows it all up. And so again, the concern here is that this is not really about, it's about what Mr.'s desires are. It's not about the children's best interests are. But when you look at the parenting plan, so again, my client notes, this is, it's a 20-year relationship. This is long-term. My client notes that she is doing counseling. I think that that's important that she be able to do that to fully understand sort of the elements of the domestic violence relationship she was in and educate herself. I think sometimes people they see their lives as sort of the norm and don't realize it's not normal. That what's happening is not okay, and not appropriate. And so again, my client's doing what she needs to do to be healthy moving forward. As far as parenting plan, again, my client is not looking to eliminate Mr. This is not a case where my client says, give him nothing, eliminate him from the kids' lives. To the contrary, my client still wants him to be involved. She just wants him to stop involving the kids in the litigation. My client proposed every first, third, and fifth weekend from Friday after school till Monday morning to school. So again, my client says, let's just remove his contact with me and allow him to pick up and drop off at school. And then every Wednesday from after school to pick up or after school till drop off the following morning to school. Again, avoiding my client, allowing healthy contact with Mr. So again, my client is trying to make the right decisions for these kids, even when that's hard, even when that's difficult. And she shows you she does that. She says, kids have done some activities at girlfriend's church. And my client says, that's not my church. I knew what was going on. It was very hard, but I went and I supported them. I went and watched them and celebrated them and didn't sort of put on a sour face about it. I did what was hard because that's what the kids needed. And so again, my client's going to put them first, and she shows that consistently. So again, her focus is kids being safe, them having a home base, and to reduce the conflict that they have to deal with. But to that note, the children should not have contact with Maggie Kennedy. That is Mr.'s girlfriend. He wants to deny that. This is a person who's now showing up, sitting, arm in arm at the kids' volleyball game, to throw that in these teens' faces as they are going through the trauma of their parents' divorce is wholly inappropriate. These kids need a break, and sports should be a safe place, not a place where parents come to gloat, not a place where they're going to bring their new girlfriend or boyfriend and sort of throw that in the kids' faces and make a scene, so to speak. That should be about the kids. And again, that shows Mr.'s focus, that he's willing to do those types of things. And again, these children's culture is a very conservative Christian culture. They need time just without the girlfriend or boyfriend. My client says, hey, Mr.'s going to move on, and that is what it is. But kids don't need to have that thrown in their faces at this early stage in the game. So there shouldn't be contact with Ms. Kennedy. So again, we're asking the court to adopt our parenting plan. It's reasonable, it's thoughtful, it involves both parents. As far as the family home, again, my client is asking to remain in the family home. Home should go with the primary parent. My client thinks that that's reasonable, that's appropriate. My client does not have some kind of magical free housing that exists. That is not a thing. That is ridiculous. It's notable that Mr. is not making the payments. He has still not made the payments. The house is 2 months behind. So essentially, right around the time this stuff is getting filed for temporary orders, all of a sudden Mr. stops paying. And I would again argue that that's strategic because he didn't know if he was going to stay in the family home or not. So he just decided he wouldn't pay the mortgage. My client doesn't have the money to pay it. And so he kind of is having the best of both worlds. If he gets back in, he'll just catch it up. If he doesn't, then he's got this pot of money to go get housing up of his own. Both parties should be required to sign I don't know if you call it a loan modification, but essentially their bank has made them an agreement to sort of forgive those payments and tack them on to the end. Both of these parties should sign that documentation and not withhold signature on it. That's ridiculous. My client is bent over backwards to keep them out of default. And both parties should sign those documents to maintain the family asset. Mr. is not reliably making the payments on the home. So again, he's tarnishing both of their credit as he fails to do that. So there's no indication that he will do that. And that's not, again, not reasonable. Mr. should not have access to the home, though, absent agreement. So the idea that he can come and go as he chooses, that should be something that he understands is not happening anymore. That he is not allowed to come into the home, and he's not allowed to use the children as a vehicle to enter the home, as have little Johnny or little Susie, hey, invite me in, because that's, like a free pass. That should also not be something that's permitted. Unless mom says yes, he needs to stay out. Personal items, my client says, hey, we just need to create a date and time. She's, again, not withheld a thing that I'm aware of. And so I don't believe that that's really an issue. As to finances, so again, when we look at finances, you have to base finances on the actual documents. And in this case, we have Mr. Through July and 2 days of August, making $100,000 and $100,140 is his total income. That is not all of August. It is 2 days of August. So if you then divide that number through 7 versus through 8 months, it makes a big difference because you're essentially cutting out, acting like he didn't get paid for an entire month if you divide it by 8. And that is what Ms. Bliss and her client have done, is they are saying, well, let me claim all of August and basically not get paid and have the court create that false average. So that's where we've provided the math directly for you. It's the 100,140 divided by 7.2. So 7 months through July, 0.2, through the number of days that is appropriate, do the fraction, and that reaches a gross income of $13,908 gross. Again, no fancy math there. We put it right up front in my client's declaration, so you could do the math if you wanted to. And that's going to leave him a net income, I believe, around $11,000. My client's income, I believe, is undisputed. She has gross income of just over $2,000 per month, net income of $1,768 per month. Child support should be based on those numbers, really straightforward. As far as spousal support, again, there is a clear and undisputed need. This is a long-term 20-year marriage, very different working circumstances, very different jobs, very different working capabilities and abilities to earn in a 20-year marriage. So this is something that is going to take time, and temporary, long-term spousal maintenance is frankly appropriate in a case like this. My client's asking for $2,500 per month in spousal support and child support. With that spousal support,
Say that number again. I'm sorry.
$2,500 in spousal support, in addition to guideline support. So the spousal support will be factored into child support, but that is, I'm not asking for that as family support. And here's why. Because of that $2,500 that she's going to receive as spousal support, the mortgage, taxes, and insurance on the home is $2,316. That's what she's going to need to pay. So essentially every month, 98% of the amount that she receives from Mr. is going straight to that mortgage. And so she's really receiving as spousal support really only about $200 for her, and then child support to support the children. So again, very small amount that's really actually going to my client. The reality is it's maintaining and preserving a community asset, which is appropriate in this case. Additionally, the court should award fees in this case. Fees are more than appropriate. I'm asking for $5,000 in attorney's fees. Again, we have a massive disparity in income between these two people. Mr. makes 5 times what my client makes. So it's not even close. And so it's reasonable that he contribute to my client's attorney fees on a temporary basis. As far as vehicles, these folks have quite a few vehicles, and essentially only Mr.'s is running well. So Mr. drives a 2020 Nissan that runs well. He should be awarded that vehicle along with any accompanying debt. That leaves a Kia, a Suburban, and a Mercedes, none of which run well. The Mercedes apparently is in the shop and needs repairs, and then for additional things on top of that. So my client says none of these things run well, none of them are reliable, and the Mercedes carries debt. My client's request is that the court award all 3 to her, allow her to sell them. Whatever funds she gets from them, she'll satisfy as much of the debt as she can, and then purchase a reliable used vehicle for her and the children. That's reasonable. Again, it's helping the parties get out of debt, gets a reliable vehicle for my client, doesn't take away Mr.'s sort of daily driver. My client should be ordered to make best payments or best efforts on the payments on those vehicles, again, with the goal being that she's going to sell them and get out from under them. As far as insurance, Mr. should be required to maintain their auto and health insurance. That should be over both the vehicles that currently exist. If my client sells all those vehicles and gets a new one, he should be required to maintain the insurance over that. It's to the party's benefit that my clients sell those vehicles, pay off debt, and purchase something reliable. So again, that's not not done as something fun for my client. And I believe there's loans on both the Suburban and the Mercedes. So again, by the time my client pays those debts, there's not a whole lot I'm expecting for her to actually receive from these, but it's better for these parties to eliminate as much debt as possible, and to be in a better position sort of moving forward. So that's a reasonable request. So again, focus here is on the children. Thankfully, in their new schools, they're doing well. They're going to play a lot of catch up. And so we're asking the court to adopt our parenting plan. The goal is to keep these children as happy and healthy as possible. We do want to keep them connected to both parents. My client's parenting plan is a very reasonable one. Her financial requests are also very reasonable. We'd ask Your Honor to adopt them.
Great, thank you. Ms. Bliss.
Thank you, Your Honor. And as you are aware, I do represent the petitioner and non-moving party, namely Ryan Yanez. Looking first at the parenting plan issue, Your Honor already made a decision as to the homeschooling issue. Despite the fact that my client wished you had ruled otherwise, he's accepting it. He's accepting it until we get more information from the guardian ad litem. Counsel's argument today largely reiterates everything that was said at the last hearing regarding the homeschooling issue, which Your Honor already made a ruling on. So I won't spend time going into that, but what I will say is even in Ms. Yanez's responsive material, she does not deny the fact that my client has played an equal integral role in these children's lives. She did not deny that he assisted her with volleyball, that he's taken them to extracurricular activities, doctor's appointments, dentist appointments. He has been just as involved in their lives as she has. She doesn't deny the fact that he has homeschooled these kids for the last 3 years, that she stepped away from the stay-at-home mom, primary parent role in 2017. So arguably for the last 6 years, these parties have equally co-parented these children, and there's not one shred of evidence before the court that indicates that that shouldn't continue, that these parties both shouldn't play an equal role in these children's lives. Regardless of what Your Honor ruled on with the homeschooling issue, there's nothing that says that my client shouldn't be able to spend the same amount of time as mother, take the children to school, continue to engage with them in church and the like. While counsel's argument says that it's reasonable that mom isn't trying to take the children away from father, her parenting plan is doing just that. Going from him providing homeschooling and the primary caretaking of these children for the last 3 years to every first, third, and fifth weekend for 3 days, 3 overnights apiece, and 1 overnight visit a week is unconscionable. It's inappropriate, and it is contrary to these children's best interest. What my client is proposing is that both parties maintain their equal role in these children's lives, that they maintain a week on, week off schedule. My client doesn't have any objection of transporting the children to and from school. There's been nothing provided that says that he wouldn't be able to do that. Honestly, mother's proposal indicates that he would do that in him dropping off on Mondays and on Thursdays and the like. So mother is consistently bringing up reasons as to why the court shouldn't award my client equal residential time without any shred of evidence. Looking to the allegations of the girlfriend, my client provides to the court text messages where mother specifically said, yeah, for lack of better words, I lied about that. I knew that there wasn't an affair between the two of you. I told the congregation and damaged your reputation. She admitted to that. So to continuously come before the court and say, oh, my client's girlfriend is the reason the kids' homeschooling isn't occurring. My client's girlfriend is coming to the games, which again was not provided to the court. There's no shred of evidence that actually occurred except for mom's statements, which is deemed uncredible based on that one text message and that one text message alone. So we asked the court to not consider that. We asked the court to order what is in this children's best interest, which is a 50-50 parenting plan. A week on, week off. There's nothing that says that he is incapable of taking care of these children's basic needs, and that he frankly hasn't done that already for the last arguably 3 to 6 years that he has been the children's primary teacher and homeschooler while mom was at work during the pandemic. There's a lot of discussions as to domestic violence, gaslighting, and the like. Yet there's no 191 factor suggested. Mom's asking the court to reduce father's time based on these allegations, and yet knows there isn't anything to substantiate it into making a 191 finding. There's a lot of discussions of love bombing and gaslighting, but my client tells you he was just as interested in the reconciliation as she was until she hamstringed him and said, I'm still moving forward with my motion. I'm still moving forward with making these requests before the court. You now have less than a week to file a response. So the court absolutely needs to take that behavior into consideration as well, not just admonishing father for whatever actions mother is claiming he made, but also taking mother's actions into consideration as well. What is in these children's best interest is equal time with the parents. I will address the issue of including the children in not age appropriate conversations or in the litigation. My client vehemently denies any allegation that he's included any of these children in them. However, going from a parent who's been an integral part of these children's lives, homeschooling them and the life, to immediately changing it to dad has to move out in 4 days, you're going back to public schools or Three Rivers Christian, there's conversations that need to be had. My client doesn't deny that those conversations happen. He does deny any inappropriate conversations or including them in litigation. These children are having big emotions, naturally. As Ms. Baldwin indicated, we're in preteen, teenage years. We have several young ladies in this case, and there are a lot of emotions that these kids have to deal with naturally when they have divorcing parents, but then having this drastic change to their day-to-day activities and their day-to-day lives. Conversations have to happen. My client doesn't disagree with any language being included in a parenting plan moving forward, restricting that kind of discussion with the children. He agrees they shouldn't be involved in it. But unfortunately, things happen, especially in early stages of the litigation. Looking next at the access of the home, again, my client's asking the court to allow him to return to the home. He continuously provides for the court that Ms. Yanez has a grandfather with a vacant home. Ms. Yanez has not provided a shred of evidence that doesn't exist. In fact, she doesn't even deny the fact that she did go to her grandfather's house in the early stages of the separation. So to say she should remain in the home, my client should pay all of the community debts, all of the expenses, spousal support, child support, and then go out and get a second home and pay for all of those expenses on what income? And we'll get to that in a minute. But as of right now, Mrs. has the ability to go to this home, hasn't provided anything that says that she can't, despite this being brought up numerous times before the court. And instead says, oh, it's fictitious, it doesn't exist, it's not there. But she also doesn't deny that she stayed there already. So we are asking the court to allow my client to return to the home, ask Mrs. to move to her grandfather's home pending further litigation. Obviously, the court adopts my client's proposed residential schedule. The children will have equal time in both parents' respectable homes, and obviously that's going to be a better situation. My client provides for the court that he's currently residing in fellow church members' homes. This is a temporary solution. This isn't a full-time situation. It's not going to be able to house 3 children on a permanent basis. So he is going to have to find alternative housing if Your Honor doesn't allow him to return to the home. And again, with what finances. So let's discuss that. I will discuss my client has provided significant pay stubs, tax returns. He provides for the court that he does work for Nippon as a cybersecurity manager. I agree that counsel's math is similar to mine, but she's neglecting the fact that there's a $15,000 bonus, a one-time bonus that occurs in March, which my client discusses in his declaration. Every March.
Hold on. I can no longer hear you. Wait, say something now, Ms. Bliss.
There we go, it just reconnected.
Okay.
Perfect.
Every March is the last thing I heard.
Very good.
Do I need to hold that wire?
No, I think maybe it's back on. If it goes off again, it just quit for the day, I guess. Okay, so every March, my client provides in his declaration, every March he gets essentially a profit-based bonus based on the prior year's projections and profits. He provides for the court that this happens one time per year. It is not an ongoing a monthly payment. And the court can see that from the pay stubs provided. It was a one-time $15,000 payment, and that doesn't change. What you do see is he consistently earns roughly $4,400 per month. That is his consistent net take home. So we're asking the court to take his gross income for the year, which is that 101 and change that counsel addressed, less the $15,000 bonus for his monthly income. And that is divided by the 7.5 months, or 7 months, dependent on which pay stub you look at. And that is his monthly income. And that is what the court should take into consideration, not a one-time $15,000 income that happens at the beginning of the year that he's then supposed to address moving forward as if he's actually getting this money, which he's not. So the court can consistently see that he does bring home $4,466 or $76 per month, or twice per month, excuse me. That is very consistent. And that is what we're asking the court to use for basis of child support calculations. This results in I have it as his net income is $8,933.50. We're asking the court to use that for purposes of the child support calculation. Mrs. income is what it is. I understand that there's been a change in her status at the school based on her reply declaration. It doesn't sound like her income has changed. Obviously, that can be readdressed later. At this time, we're asking the court to adopt her income as presented by her. Lastly, my client addresses the fact that he provides for the children and Mrs. medical insurance, and he provides the breakdown as to the costs associated with these. That is $290.34 every single month. So he's asking the court to provide credit for that within the child support worksheets. I do believe that that is appropriate. Granted, whatever monies Mrs. pays for the youngest child's tuition at Three Rivers Christian, she should be applied that credit as well. And lastly, if the court addresses or approves of my parenting plan that my client has proposed, which provides them equal residential time, we are asking the court to award a residential credit. Again, dependent on what the court decides to do with the home, spousal support, and the like, all of that needs to be taken into consideration. Again, my client's budget at the beginning of this case shows that nearly 100% of his income and his income alone is dedicated to the community debts. So if your honor is going to order that he maintain those debts and award him 50-50 custody of the children, he is asking for a residential credit. There just simply is not enough money to go around, despite Ms. Yanez's arguments. So that's what we're asking for the court. As for fees, I understand that there's a disparity of income, except for the fact that my client provides, he simply cannot afford his own fees, let alone Mrs.'s fees. And again, his budget and his actual income are reflective of that.
Does your client, and I don't know if I guess I don't know which declaration this came in, or if it was one of the recent ones, any position on the 3 vehicles?
I do believe he addressed that in his last vehicle. It was my understanding that the Suburban was the oldest child's vehicle. But his request for the court was that he maintain the Suburban and the Nissan, which he purchased after the separation, and that Mrs. maintain the Mercedes and the Kia. And whether she sells them and satisfies the debts and purchase a new vehicle, I didn't get his position on that, but I don't imagine that would be an issue.
And so your understanding is that eldest child is using the Suburban, like, to get to school and practices and whatnot?
That's my understanding.
Okay, thank you very much. Ms. Baldwin, anything else?
Yes. First off, just to address that question directly, my client's fine if the Suburban should be awarded essentially for the child to drive. It does have a debt. So essentially it should be labeled as child's going to use it, Mr. pays the debt. We're fine with that car not be sold off so long as Mr. is willing to pay that debt on that vehicle. The Kia and the Mercedes, my client should be awarded and be able to sell those, because the Mercedes has like $1,000 a month payment. It should be sold off as fast as they can with the best efforts towards the debt, because there's just I'm not sure why the debt on that vehicle is so high. It just is. My client's in favor of appointing the guardian ad litem that's getting on board, so that's good. Again, there is use of conflict. Counsel's statement is essentially like, well, gee, things happen. No, they don't. You're a parent. It's ridiculous that a parent would come home, be emotional, and then instead of protect their children from a rough situation, essentially then spill all over them, emote all over them, and try to align them with himself. That is not appropriate. He did not have to tell the children the details of what was happening, the details of the court process, what the parties were taught, what the parties said in their statements and declarations, and then lay blame on one of the parties. That was not helpful to that child. It certainly wasn't. And that's the youngest child. So again, this idea that Mr. can manage himself, he's really not evidencing that, even in the presentation here. The text messages regarding Maggie Kennedy, again, this is an evolving situation where my client had some information at some points in time and more information at later points in time, but there is definitely an inappropriate enmeshed relationship. The children need to be segregated from for a period of time, regardless of what that relationship is. Children need to not be in the middle of it at this point in time. So again, my client's not saying forever. She's just saying, let these poor kids heal. before they're being sort of shoved into Mr.'s relationships and difficulties. And again, Mr. makes poor choices regarding age appropriate materials. The book that we submitted is grotesque. That is not, it shows people essentially murdering each other in very grotesque ways and advice on how to do so. The idea that you would give that to a young person just isn't appropriate, and sort of indicates sort of, I think, Mr.'s, again, what he desires and sort of this need to align. I think that you see parents who do things that are inappropriate with children and allow them to have things they shouldn't have periodically because he's aligning them with himself, because that is satisfying to him. So again, we're asking the court to adopt my client's parenting plan. It is extremely reasonable. It gives kids a home base. It maintains relationships with both parents, and it keeps the parties separate, which I think is appropriate at this point in time to reduce conflict for the children. As to the family home, again, my client indicates I don't have free housing. She's never stayed anywhere overnight in the recent past since they've had these troubles or since the divorce has been filed. So there's not some place she can go. That is not a thing. Mr. has stayed places overnight. He has places available now, and his income indicates he has the ability to purchase and a rental for himself. My client, and that's where the incomes and sort of the part of the breakdown of what each party is receiving is important. So my client would indicate that the bonus is consistent. He gets that every single year. Deducting that is just sort of giving him a freebie that's not based on any evidence. He has nothing from his company saying he doesn't get that. He does not. And while it's in his possession and control, he could have easily have provided, hey, here's last year's W-2 and the W-2 before that showing I didn't get those monies. Didn't do that either. So again, the statement of, oh, gee, this isn't, I'm not going to get this. My client says no, it gets it every year. So again, when you look at my client's requests, so essentially Mr. has a net of about $11,000. My client has a net of about $1,700 pre-child support, pre-spousal. If you take away from Mr. $2,500 per month in spousal, $1,922 in child support. If you take those away from him, that's going to put him at an income of about $6,500 to $6,600 per month net that he has to live as one person. So again, $6,600, he's got as one person to live on. If you add $2,500 and the $1,922 in child support to my client's income, she has $6,200 per month net for 4 people. So 4 people on $6,200 per month and 1 on $66. So my client's requests are very conservative here, probably too conservative. But again, my client isn't trying to be unreasonable. She's trying to put both parties, trying to think about both parties moving forward. But so again, my client's requests are very reasonable and trying to take care of the children. If Mr. provides any sort of evidence of the actual breakout for the medical costs, I'm happy to include those in the child support worksheet. Ms. Bliss knows the HR documents that I'd be looking for. Happy to include that per statute. That's fine. And similarly, my client, the credit that she receives for the tuition, that should be included on my client's side of the ledger as well. That's appropriate as indicated by Ms. Bliss. So with that, we are asking the court to adopt our parenting plan, adopt our child support worksheet numbers, the requests for spousal maintenance and child support and attorney's fees, and the division of property as indicated.
This is a difficult case. When you have these longer term marriages, it's always unfortunate, difficult to see, and you really do have to consider the children in this case. There are some, frankly, this is a no fault divorce state, so a lot of the accusations kind of the court isn't as concerned with. There is concern with, involving the children. So there obviously there should be no disparaging comments between any of the parties and the children regarding the other or anything to do with the court case. I will award the Suburban and the Nissan to Mr. Mr. will take over the finances for that. The Kia and Mercedes to mom. Mom is free to, or Mrs. is free to sell those and get rid of the debt there. And that will be something that'll be just logged for as we move forward. And the Suburban, I guess, while dad is taking on that debt, that's, I think it's agreed by the parties that that's a vehicle that's used by the eldest child. And if they're unlike or like any other eldest child, then they're maybe ferrying around the other kids to assist parents, and that's acceptable. And so Suburban will stay. Mr. maintaining insurance is appropriate, and we'll ask him to continue to do that. And I agree there should be if there's a significant cost for that. So himself, Mrs., 3 children, he should be given credit for that as part of any maintenance or support that's ordered. With Miss Kennedy, I understand the concerns that Mrs. has. The only thing that I guess I'm a little bit hesitant about is it sounds as though that there are some, and I could be incorrect, so if I am, please tell me, but the way I read it, it sounds like there are some church-based activities that she's involved in and or leading that the children are participating in that originated prior to this action being started. So I guess I would like her contact limited to those church activities at this point in time. And I'm happy to review that as we move down the line. But at this point, I think just to keep things professional, especially given kind of the history of the parties and the length of the marriage. 20 years is a significant period of time. And I understand mom was at home with the children for 16 approximately of those 20 years. And dad's been kind of more of a at-home primary since right before COVID or COVID. So the last 3-4 years. And that does make it difficult, especially when you're homeschooling. That's a lot of time that mom went back into the workforce and dad kind of took over at home. And going back to that, mom should get credit for the tuition that to offset that as well. So that needs to be factored in. I'm looking at the financial declarations, and there's a lot that's been provided, and I went through a lot of that. What I did notice is that I came up with this. I had $89.32 per month based on standard payments. Doing the math with Miss Baldwin's numbers, yes, and then that clearly includes that bonus that comes once a year. In the records, there's nothing that shows that he doesn't get that every year. If it was a $3,000 bonus, I wouldn't be concerned. A $15,000 bonus it's essentially 2 additional months of pay. So it's a pretty significant bonus. And I do think that should be incorporated into the numbers. That being said, understanding it's an annual one-time thing, I am going to factor that into ultimate number because it's not getting doled out over the 12 months. It's a one-time thing, but hopefully there's planning and savings and all that good stuff. As to the parenting plan, there are some concerns with just, frankly, that book is a little bit wackadoodle, that's something that would be provided to a teenager. I don't know the interests of these children. I don't know if this came from a particular place. And I do think that parents sometimes step out of their comfort zones in order to align themselves with children and or try to find a common interest. This is a little bit of a concerning one and weird one, but I'm not really basing a whole lot onto that, other than I think that kind of information probably shouldn't be shared with children. Just kind of note. The finances and the parenting plan are so closely combined that it's difficult. I do understand if we assume dad's income, let's just say it 10 grand a month, that kind of evens out that bonus a little bit and taking away taxes. Do we, let me see if there's it sounds like Ms. Baldwin's indicating that there are no additional homes for her to reside in. I think I took that into consideration last week when I awarded her the home. I don't have anything to say otherwise, other than she's continually indicated she does not have another home that she can go to. The mortgage is $2,300 approximately is what I have in my numbers. So for dad to maintain that and pay $2,500 in spousal support, and what would ultimately be, I'm going to just guess, I can't remember which sheet I was looking at, but I'm going to say $1,500 in child support. So, and that could be high or low from what we're working on, but that's approximately $6,300 of his take home, and then having to rent a home on his own, where we are depleting the funds pretty significantly there. And I do recognize that. Here's what I'm going to do. So the standard calculation in at least this one that I'm reviewing has child support at $2,800. That's Miss Baldwin's number 2. That doesn't have any, actually I take that out. So the transfer would be after at least some of the credits. Is that correct, Ms. Baldwin, 2,800? Am I reading
So
that?
it's 2,800. That gives him see, that's with my client receiving a small, like a $300 credit for education costs. And I think that's not counting any of the medical costs towards him though. So there's uninsured medical costs that my client was presuming she'd pick up of around $80, but we didn't have any information on the children's portions to include.
That also is with his wages being set at 15,717 a month. Okay. So I'm gonna you both know that I hate math. I'm gonna set his income at 10,000 a month.
Okay.
And so I
Is that
want,
net or gross?
That'd be net.
yes. And then we'll let's work off of that number. So I won't have a final number for you. As far as the parenting plan, there's part of me that completely agrees with Miss Bliss that there's no reason to limit Mr.'s parenting time, and that there is kind of a want for the court to start at a 50-50 parenting plan. On the other hand, I understand the arguments for every other weekend, Friday to Monday, and Wednesday, every week, Wednesday to Thursday. Here's what I'm going to do. I'm going to do week 1 will be the Wednesday PM to Thursday AM. So, and I say PM, I mean after school. So Wednesday after school to Thursday AM, and then Friday after school to Monday to school. And then week 2, week 1 would be, I'm going to start all over again, and I apologize. I'm going to do Wednesday after school until Sunday for week 1, or excuse me, until Monday at school. And then that week 2 would be just the Wednesday after school until Thursday morning.
Okay.
And then the next week it would be Wednesday until Monday AM. Does that make sense?
Yes.
Miss Bliss, ask a question if you have it. So it would be
I just want to make sure.
Wednesday, week 1. So Wednesday after school until Monday at school.
Right.
And then he would get that Wednesday just one night. And then it would be 1 week. And then he would get Wednesday through Monday AM again.
Okay. I think I'm following.
And I guess if that Wednesday overnight in the off weeks is better to be a Thursday night, or, based on the kids' schedules, I'm totally okay with you all moving that around. But essentially I don't want more than a week between contact there. So if Thursday works better for schedules, I know Wednesday is an early release at Longview, and they, that could be the best day. If Thursday night's better, I'm fine with that, or a Friday night. But there would be an overnight and then a longer stint. So that'll obviously factor into child support. So I will defer to the Council on Child Support and running your numbers and your fancy computers program that you have. I discussed the CARS child support. Will kind of need to be rerun based on that. I think we all agree on mom's income, so I'll adopt that as her income, and then giving the credits to both parties. As for the request for spousal maintenance, what I am going to do is I'm going to give, this is a long-term marriage, 20 years. She is working now, wasn't at the time, or excuse me, wasn't for primarily majority of the marriage. I'm going to award some spousal maintenance. So I'm going to award $1,500 a month starting September 1 for 6 months. And then I would like to review at that point in time. As for attorney's fees, there was a request for $5,000 in attorney's fees. Given the discrepancy in finances, I'm going to award $3,000 in attorney's fees to her with a 90-day payment before accruing any interest. And that'll be a one-time only deal.
So
Anything I missed?
okay, a couple
Yes.
questions. So the first question is because Mr.'s housing, so it's my understanding the court's having my client in the primary home or in the family home. Is when does he start his overnights? Because my client's just concerned about he doesn't really have housing. And so she's fine with he has housing, but also doesn't want the kids, we have 3 kids to sort of be flopped on a couch somewhere. So she'd asked us that they be day visits, at least on school nights, until he can get some kind of rational housing. It doesn't have to be perfect, just rational setup.
Does he have, what's his housing situation?
So, Your Honor, it's my understanding that he's been staying with another couple from the church, and Your Honor had previously ordered that he have overnight visits in the 2 weeks that we've been waiting to come back before the court. So I don't think that that's been an issue. At least it hasn't been brought to my attention that it's been an issue that the kid's sleeping on a couch.
There's a big difference between a weekend and this is like a 60-40 plan. That's a big difference. I mean, kids on the couch on a Friday night is one thing. You got math test in the morning, rolling around in the sleeping bag on the floor is not real reasonable. So again, my client's not saying no to Your Honor's order. She's just saying, can Mr. get some rational housing before the kids are kind of in an unfair spot to them?
Is that, I'm assuming, Ms. Bliss, was he awaiting today's hearing to determine whether he was going to look for housing? And I understand that, and that may not be something that can happen super quickly. I get mixed messages about the housing market here, and obviously 3 children is going to impact what he's able to get. A studio apartment, obviously, it's not going to work. I completely and totally understand mom's concerns. I think at this point, I'm just going to stick with my order. If concerns arise, or if there's issues, or if he's choosing to not ever look for housing and just live off the good graces of others, and it becomes an issue, then I'm happy to readdress it. But I'm going to assume that he will make efforts based on the rulings to try to get set up somewhere that will work for them all in a reasonable amount of time. He would have to do that if I adopted his parenting plan. So I'm assuming that since I practically or came close to adopting his plan, that he'll make those efforts. But in the meantime, I think he should get his overnights. Next question.
So the other question that I have is just regarding payment on the mortgage. The court can, and so Your Honor's ordering a deviation, and it sounds like you're ordering a mathematical deviation based on overnights. My concern is that will, does the court want to look at that at presentation, since we don't really know what those numbers are going to look like? My concern is that the amount orders is not sufficient to meet base household requirements. As far as it's fairly high mortgage for these folks. There's also the vehicle debt that my client's being handed, a pretty significant vehicle debt she has to service until they can get those vehicles sold. And that won't necessarily equate to no payment there either. So my concern is just simply that that's sort of my concern. So we don't have those numbers kind of quite fleshed out to be able to look at what that really means for the parties' incomes.
I know I kind of went rogue on everyone, and I couldn't even venture to guess what the numbers would work out based on kind of where we went. I'm fine with hearing more about that at presentation.
Okay.
And I'm assuming that's actually a benefit probably to both parties, just because we want to, if it is it appears to be, based on what I've read so far, their largest asset. I'm sure they want to protect that, and for as long as they can. Presentation is, and you may have more questions, but presentation wise, the next court date available is the 26th, or if we don't take a Friday, just so you both are aware.
And I'm okay with the Friday when we get there. But then I do want the court to make an order on the back payments on the mortgage. So if my client's going to pay the mortgage,
right,
either Mr. has to catch it up, and that's my preference, is he has to catch it up because he's withheld the payment for 2 months, or he'd be required to sign the loan documentation, whatever it is that allows. But my client should be in a position where she's paying more than the mortgage previously. That's not reasonable.
And then the other option is the bank is willing to essentially forgive those couple months payments and just tack them to the end of the mortgage. Is that correct?
I think it's either that, or there's a small payment associated with that, where it's kind of like they recalculate your monthly payment. It's one of those two things that results in either a small increase or tacking it to the end. It's one of the two.
Okay, Ms. Bliss, what's your client's position on that?
And frankly, Your Honor, I don't have a position on that. This is the first. Counsel's argument was the first I was really hearing that there was that option of tacking on at the end, or and frankly that they were 2 months behind. Last I had heard they were only 1 month behind. But nevertheless, I think it's appropriate, obviously, to get the mortgage caught up. I think it's a benefit to both parties moving forward. I would say whatever's the least costly or at least financially burdensome, obviously, is a better option for everybody involved, especially with the fees and everything else that Your Honor has ordered my client to pay, at least at this point. So maybe we revisit that at presentation once we can get a little bit.
I'd like to revisit that. And I know Ms. Bliss doesn't have this information, but they're now 3 months behind because we've now lapped into the next month. And it's a recalculation. So they just add that back into your principal and then recalculate the payment. So that seems reasonable. So I'd ask that he be required to sign it so that they don't just keep digging a deeper hole. And then second, once he signs that, then whenever we set the presentation, he should be required to sign it, like essentially today. We can bring that with the recalculation, and the court can consider all of that.
I think that's fair to assume that I didn't look that much into the finances to see like what savings or what any of that entails. And I understand that he's going to have a lot of out of pocket initially. So I think him signing that statement with the bank I say forgive the payments, but essentially roll them into the back end of the mortgage, I think is probably most appropriate. And I will order that he sign off on that as soon as possible.
And then start date for financial orders. We filed in August. I'm asking August 1. Mr. has been paying the mortgage payment. So it's kind of realistically, I would argue they financially separated before then. But my documents were filed August 3.
Ms. Bliss, any position?
I believe Your Honor ordered a September 1 start date for at least spousal maintenance. That would be my request, just to keep everything congruent.
That will be the court made an order on the start date. And that puts my client financially quite behind when they've clearly been at financial differences starting in August when she filed and served.
I did say that I did say September. So Ms. Bliss is right on the spousal maintenance. Given the time of filing and everything, I'll switch that. We'll do it August 1. Okay. And then that'll put us 1 month sooner for the 6-month review on that.
Taxes. So I would ask, based on where we are, priorities filed jointly for this year, and that any amount received be held in trust until either court division or agreement of the parties.
I don't have any objection to that. I think that's appropriate.
So it'll be so ordered then.
Okay.
It does. I can do the 22nd at 8:45.
Okay, very good.
All right.
Wonderful.
Thank you very much.
Thank you.
Unfortunately, I do not have the stream from Judge Fassett's presentation docket on September 22nd, so I don't know if there were additional objections to the orders or what effects the details of the parenting plan ended up having on the child support. The only thing the comment tells us is the list of documents each side submitted to the court. It includes the child support worksheets and all the other orders that they wanted the court to sign. I assume that all the orders were signed by the end. The only thing I know for sure that she signed that day was the $3,000 judgment in attorney fees to help cover some of Attorney Baldwin's bill. 4.5 months later.
Number 8 on the docket, 23-3278-08, Yanis v. Yanis.
That matter's ready. We're on for review of the guardian ad litem report. Guardian ad litem report is obviously not in the file. There's a lot of moving pieces. The court might see that a motion to modify temporary orders and a contempt has been filed. I think that's on for 2 weeks from now. So there's a lot of moving pieces. Guardian ad litem can speak to how much time she thinks she needs. Realistically, again, a lot going on with these kids. And there was a lot going on with the family. I think 60 more days is honestly reasonable.
So do I have Ryan Yanis here?
Yes, Your Honor.
Okay. So would you agree with what Ms. Baldwin has indicated?
I want to give Ms. Turnbull as much time as she feels necessary. So if 60 days is what she feels is appropriate, then that's what I'm wanting her to have. I feel she'll get to the bottom of everything and ultimately have the best interests in mind for the kids.
Ms. Turnbull?
I think 60 days is reasonable. Mr. Yanez and I have just made a final payment agreement, so that will be, hopefully he will be able to, follow through with that, which will be helpful as well. And I do have some, pretty serious concerns about the children as well.
All right. So anything else, Ms. Baldwin?
Just let's set a review. So I'm thinking, 60 more days would put us about this time in March. So maybe the end of March, March 26th.
Okay.
I'm going to be out of town that week.
How about, let's see, April 2nd?
I'm out April 2nd, but I can do April 9th.
I can do April 9th.
Mr. Yanis, does that work for you?
Yes, ma'am.
Okay.
That's on Thursday.
April 9th is a Tuesday, 2024. So we'll go ahead and set it to April 9, 2024 at 9 a.m. For a final review.
Very good. Thank you.
All right.
Thank you.
Your Honor, I believe Mr. Yanez walked into the courtroom. We can take that matter if you're ready.
Your Honor, Ostrander is ready to go too.
Okay, just a second. Go ahead and take the Yanis matter 23-3278-08.
So for the record, I'm Chelsea Baldwin. I represent Amy Yanez. This is our motion for contempt along with our motion to modify temporary orders. We also have the guardian ad litem with us, and that's Ms. Turnbull. Services in your file effective on the 12th of last month. It's been nearly a month. There are pressing issues that directly impact the health and safety of the young people in this case. I'm essentially going to address some of the financial issues.
Ms. Baldwin, I'm sorry, just a minute. I'm looking for my notes, so I'm not sure where oh, here we go. I'm sorry, go ahead.
Your Honor, if I could
To address the financial issues, talk about some of the parenting issues, and then circle back around to the financial issues to wrap it up. We do have two motions, and I was just planning essentially to address them all together, unless you want to address one motion at a time.
Okay, so Mr. Yanis has something to say. Let me hear from him real quick. Go ahead, sir.
So I currently don't have legal representation. I'm asking for a continuance so I can get the time to acquire new representation.
Okay, how much time are you talking about?
I currently have a appointment set up with Chad Zandy's office March 4th. And then I have two other attorneys that I'm trying to meet with as well that are scheduled out in 2 weeks. So I'm asking at least 3, maybe 4 weeks.
Ms. Baldwin?
So my issue here is that we have a young person that's engaging in self-harm during the father's time. And the belief now is that the father's also medicating the child on his time and not telling my client. So those are substantial issues that simply cannot wait. If we have a child that's or self-harming, we can't just kick the can down the road while that child is self-harming in the father's care. That is the chief concern. I don't have any significant issues with pushing financial issues or even the contempt down the road. I do have a health and safety concern for the child in pushing the children's issues on the parenting plan.
I don't recall exactly, Ms. Baldwin, if I continued this for 2 weeks, how many visits would Dad have between now and then?
You would still have, and it depends on where they are in their rotation. So this is essentially a 60-40 plan. 1 week he has like a single day, but the opposite week he has 5 days. So it depends on where we are in that. If the court wants to enter an interim order that just says we're not going to do visits between now and that would be the 20th, that would be acceptable. Or that there would be minimal visits between now and the 20th. I think that's a way of mitigating those issues of the health and safety issues. But that's really the chief concern.
Your Honor, the weekend of the 16th and 17th, that's the next full 5 days that I have with them.
So is that the only time that you have?
And then, well, every Wednesday.
So
Wednesday, tomorrow
yeah.
I will have them, and then on the 14th, I will have them through the 18th or through the 19th.
Right. So it's not just the weekend. It's Wednesday through Monday morning on 1 week, and then a Wednesday to Thursday overnight on the following week. So it's a 5-day stretch. And again, where we have a child self-harming, that's the problem.
Yeah. So I did review the file. I understand you're not represented, and I can appreciate you want to have an attorney. At the same time, I'm concerned about the safety of the child as been indicated. I'm not saying it's true or not true, but I have concerns just based on what I've read. So
Has this been presented to the court, Your Honor? Because I have not heard of the self-harm or this accusation?
It was
medication?
in the documents that I read. So, if you want to meet with it or set this over a couple of weeks, and reduce down your time, I'd be willing to, set it over the 2 weeks.
And reduce my time
Yes.
with all my children?
Is it just the one child you're concerned with, Ms. Baldwin, or?
No, because the other child are being involved essentially in the deceit. So the one child self-harming, there's 3 total children. They are 16, 15, and 12. It's the 12-year-old that's self-harming. The 15 and 16-year-old are being directly involved in the deceit. And then we now have a case over in juvenile court, which there was no reply, so I wasn't able to put this in because there's nothing to respond to. But we now have a child that's becoming delinquent and on the truancy docket, or was starting to be a part of that docket. So there are substantial concerns.
And Your Honor, the juvenile case is actually,
Okay, I don't want to get into it. The only, so
my point
I'm
is
not really
during
concerned
the
about the
time.
juvenile. It's the other part that I'm mainly concerned about.
Yeah, I'm unaware of her self-harming. She is medicated while she is with me. That is under her doctor's orders and a prescription that's been prescribed from the doctor.
And medicated while she's with him. That's such a
That's
key
because the mother
concern.
isn't following the
I
doctor.
can't hear both of you.
Is that he didn't notify my client, so she's only receiving medication while she's with him.
Your doctor, or Your Honor, the doctor was actually, my wife was with the doctor during the physical when the medication was prescribed. I was not notified of the medication and actually had
Okay.
to read
So
it.
I'm going to stop this here. If you want to set it over 2 weeks, I'm going to reduce the time because based on what I've read, I have concerns. I'm not saying they're real or not. I'm just saying at this point, I have the concerns that I feel like at least something, if we're going to set it over 2 weeks before you can get an attorney on board, that's my concern. So I wouldn't necessarily reduce it a whole lot, just to the weekend time. And so you have the 7th through the 11th and then the 14th, is that right?
No, Your Honor, I have them every Wednesday, and the next full stint will be the 14th through the 19th.
So he would have this Wednesday so he did the 7th to the 8th would be his regular time. And then the 14th through because of the holiday, I think it'd be the 14th through the 20th would be his regular time.
14th to the 19th.
19th. It would be the 20th. So you could have the 14th. Just the evenings of the 7th, the 14th, and then the weekend, 16 through 18.
Okay. And
Eliminating the Friday, the 15th,
Friday's the 16th.
16th, sorry.
So it'd be Friday to Sunday.
Okay.
the court's intention is for the 7th and the 14th to just be day visits.
Right, evening visits.
Right.
Evening,
Let's do after
overnight.
school to after school till 7.
They're older, it can be 8.
Okay. And then Friday after school till Sunday and use that same 8 p.m.
Correct.
Your Honor,
Okay.
could we move the Wednesdays to 9? The kids are usually at youth group.
I'll make it, I want it at 8, get them home.
Just
Do you want to do that, or what do you want to do?
What are
Up
my
to you.
options?
If you want to think about it, you can.
Sorry. So if I didn't want to do this, then what?
We would go forward today. But like I said, I have enough concern based on my reading of things that I would limit things at this point.
I'm not prepared. I have an attorney, so.
All right, you're still seeing them. It's just for less time. Okay,
Your Honor, there's significant issues of concern with their mother's care. CPS is involved. There's a
I
protection
don't
order
have
against
any of
her.
that in front of me, sir. Do you want
And I
to
don't
do
have
this?
this accusation of self-harm and medication in front of me.
Sir, which do you want to do? Do you want to argue it today or do you want to continue it?
I'll take the modification of the time. I
What's
need
that?
more time to find attorneys.
Okay, so do you want to go with the 2 weeks?
Yes, please.
Okay.
Your Honor, do you want to do a bench order or do you want me to just, I can do a quick interim order. It's your call.
You want to do a quick order and get it over to me and then get it to Mr. Yanis?
Let me make sure I have his email address.
I can rewrite it for you if you need as well.
Your Honor, how do I get a copy of what's accused?
So long as it looks like it's correct, sir?
No,
Okay.
Okay.
What's your email? RJ.
At Gmail. Okay. I will send that to him today to review and sign. I would just ask that he review and sign. It's
So-
pretty straightforward.
Have you not been served with the documents?
the only ones I've been served with are contempt and a modification of parenting plan. There's nothing in there about self-harm or medication.
He's saying he hasn't received anything that has about the self-harm and the medication, which I read that's been filed. So can you send him another copy of everything?
I can. He was personally served, and then he also had an attorney when we served him, so I sent her a copy as well. So he's actually gotten it twice, but I will send him an additional copy.
Okay, just let's make it sure that there's no question. So when we're here next time. Okay, so give me an order, Ms. Baldwin, and email him the documents. I read it as RB2 in the file, so I think that may be part of what's going on.
RB2, sorry.
So it's RJ in
Oh.
your email. Okay. All right,
Okay.
so we'll set this over 2 weeks to February 20 at 9 o'clock.
Your Honor, the domestic violence protection order hearing is at the same time against Amy, so to move that
Okay.
to a different time.
We'll address that with that court.
Yeah. Are you the attorney on that matter, Ms. Baldwin?
I am not at this time. I'm aware of that case. It has not been properly served on my client. So instead of responding to this case, he filed a DVPO and then it hasn't been served on my client.
Okay. So what you need to do is on that day is go ahead and let that judge know that you also have a hearing here.
Okay,
Hopefully you'll have an attorney and it can be handled through the attorney, okay? And that way you have your time in each court, okay?
the difficulty is, I mean, the soonest I have is with Chad Zandy's office, March 4th. I'm not going to be able to get an attorney by the 20th.
I'm giving you 2 weeks to take care of it. I don't know what else to tell you at this time. I'm not going to set it out to the March based on what I've read. So it's up to you what you do in the next 2 weeks. Okay,
Thank you.
all right, that's it for today. All right, taking number 7 and 8, Yanis v. Yanis, 23-3278-08.
That matter's ready. And just for the court's reference, we do have the guardian ad litem with us, Ms. Turnbull as well this morning. This is on for our motion for contempt as well as our motion to modify the temporary order. At this point, service was effective January 12th. We've set this matter over now more than a month. There are and continue to be pressing issues. I'm going to address the contempt first and then sort of move into the parenting plan issues and temporary or modification of the temporary, and then kind of go back to some of the financial issues at the end. Regarding the contempt, the first very clear contempt is the failure to pay spousal support. In this case, the court found not that long ago that Mr.'s income has a net income of $10,000 per month. And this was before we found evidence of his second job. He is able to pay the support that the court has assigned to him. And he's specifically chosen not to pay spousal support specifically. This has very direct financial impacts on my client and the community finances. It meant that she was unable to make car payments, resulting in one of the vehicles being repossessed. And there's now a rearage that's owed on that car, even though it's been repossessed, and also makes it so she's unable to pay the full house payment, which is a hefty house payment, which we'll address as well. That puts the house at significant risk of foreclosure, in addition to hurting everyone's credit. The arrears at this point exceed $7,000 in spousal support. As far as the parenting plan, there are multiple contempts. When we look at the parenting plan at section 5A, the children were not to attend the homeschooler co-op group that was part of Maggie Kennedy's co-op group due to sort of the level of toxic interference that that individual had with these children. And the court had really carefully tailored sort of what the children's interactions with that person would look like, and sort of really narrowly and carefully made an order in this case. And so what Mr. did to get around that is Mr. and Maggie Kennedy then set up additional new groups to involve the children in, so that the children that are being involved in these new groups with Maggie Kennedy and the homeschool group. And we see that occurring on Mr.'s Fridays on October 13th and on January 6th. These are on Mr.'s regularly occurring Fridays, where then he's placing these children back with Maggie Kennedy in this same homeschool group of children. And this is critical, not only because they're being involved with Maggie Kennedy, but they're also being involved with children that have mental health disorders that impact the children of this case. One of the children in the homeschool group, unfortunately, is a child that self-harms, that self-injures. That child and one of the children of this case then sort of feed off of each other in doing those behaviors. And so the goal was to limit these children's access to each other, in addition to limiting the children's access to Maggie Kennedy. So it had a dual purpose. And Mr. then decided that instead of obeying the court order, they would create these new groups and then push the children into these groups. This was specifically prohibited under the order. It was the children can attend things they are already doing that are not the homeschool group. So essentially, if they were going to a Wednesday night youth group, they could continue to do that. But this is not that. They created a new group and then sent the children to this group. So again, Mr. should be held in contempt for that. As to parenting plan section 5A, this is joint decision-making. Mr. engaged the child with a therapist that is not her regular therapist for mental health purposes, refuses to provide my client the information, continues to refuse to provide that information, refuses to provide details of the visit, why the visit occurred, who it was with, when it was, refuses to engage in joint decision-making. Again, my client becomes wildly concerned that the child is now being medicated with mental health medications that, again, there's been no joint decision-making to use. And when we have a child that's on these medications in one household and then not in the other household, that creates huge concerns and huge problems when we talk about prescription medications. And again, this is all without my client's ability to participate, to be aware, to talk to the provider. Direct violation, very clear violation, and a dangerous one at that. This is not a minor violation. This is the whole point of joint decision-making, is so we have providers that are aware of what's going on. We have parents where both parents are aware, so that if something happens during either parent's time, that parent can correctly tell another provider or an ER, hey, this is what's going on. These are the medications that are being used. My client's intentionally left blind by Mr. The next issue is school attendance. That's section 14B of the parenting plan. The children were not to attend the homeschool co-op. They were to go to traditional school. The underlying issue of this case is Mr. homeschooled the children. He unschooled the children. The children were professionally tested. They were found to be years behind in education. As a result of that, the court ordered them to attend traditional schooling. All the children were then enrolled in traditional educational programs, either in public or private schools, and that they were to attend those and not to attend this homeschool group, both for the educational purposes as well as the problems we've already talked about. Mr. then, during his time, was pulling the children on Fridays from their traditional schooling and taking them to the homeschool group. That happened October 20th, November 3rd, and then again on November 17th. These are all Mr.'s Fridays. And so you see the children being pulled out of their incredibly necessary education, where they're already behind, where they're already needing to do heavy lifting as children to frankly catch up after years of educational neglect on Mr.'s part. And so then Mr. just decides, well, I'm just going to pull him out because it's what I want to do. So again, Mr. Direct Contempt, really just no excuse here, just does what he wants to do and moves on. Moving into section 14D, this is involving the children in conversations and the litigation. It's clear that Mr. is having direct conversations. Some of these are happening quickly in front of my client. He's crying in front of the children saying, you're going to have to choose between your mother and me. You're going, and that they can choose. And again, these are things that A, aren't true. Children don't have this choice, and B, they don't have to choose. They shouldn't be placed in this position. This is directly emotional manipulation of the children. It involves them in the litigation. It's inappropriate on every level. And Mr.'s doing it out in the open in front of my client and in front of the children. This puts, and it's encouraging, in addition to these things, he's encouraging the children to not tell my client critical things, such as one of the children self-harming during the father's time. So again, huge concern that we have a children that's engaging in self-harm. Father hides that, hides why we had this emergency mental health appointment, and then tells the other children to, be quiet about it. So again, that's involving them in that litigation. In addition to doing these things that are out in the open, he's also secreting that information, making the children direct participants with him. So for these reasons, we're asking the court to find contempt. We're asking the court to find the arrears. At this point, we'd ask the court to find the arrears of $7,113 plus interest, plus because we've been delayed at this point due to Mr. quite a bit, any additional arrears by the time of presentation, we should be able to add to that judgment. I'll ask the court for fees of $3,500, costs of $85, and a sanction of $1,000. When somebody chooses to pay child support and intentionally not pay their spousal support, they're making a very direct and intentional choice to do that. And so that warrants a heavier sanction. As far as the parenting plan, the court should modify the parenting plan at this point. It is warranted, and these children are not doing well under the current parenting plan. The current parenting plan is essentially, I would say it's like a 60-40 type of a parenting plan. Mr. has essentially expanded weekends and then a midweek on the off week that's an overnight. We're asking the court to move that to a more traditional parenting plan, which would be Mr. has alternating weekends from Friday to Sunday. In this case, we have Shiloh, who is self-harming during her father's time. We have Mr. that is hiding that fact, refusing to disclose it to my client, and encouraging the other children to withhold that information from my client. There are continued issues with Mr. And the contempts that we've mentioned. So again, those are all things that are really directly involving the children, that especially the issues surrounding school, where we're trying to get these children on track, trying to get these children to be brought up to speed educationally. Mr. just directly interfering with that, which puts the children at risk. But it also shows the kids this, you don't have to follow the rules. You don't have to do what your teachers say. It causes all of these sort of down the line impacts to these children that are incredibly negative and make it really hard to get these children back on track long term and to be successful long term. He's involving the children with toxic individuals, and one of those is that Miss Kennedy, folks that are encouraging the children to be dishonest with their parents. Again, that's hugely problematic when we have people doing those types of behaviors. And frankly, we just have a plan that isn't working. Again, we have Mr. who has years of this failed sort of homeschool attempt and this prior educational testing that shows us that it's a failed, it did not work. And Mr's directly trying to undermine the children being able to be educated by pulling them out of school. The child Shiloh self-harming, we have, it should have been really a place where parents really rally, and circle the wagons and everybody comes together and everybody participates because everybody just recognizes, hey, this is really serious. And instead of doing that, Mr. then chose that opportunity to do something really dangerous and really put that child at direct risk. Essentially see a child that's self-harming and send that kid back to mom and stay silent. Put child on medications and not say anything. So child's being medicated in one home, but not the other. So again, huge risks here. And again, these toxic individuals. In this case, the best interests of the children really are served by placing the children primarily, and they're already primarily at my client's home, but placing them with my client and putting changing father's visitation to an every other weekend plan. That allows for higher levels of stability for the children, more consistency for the children educationally, more consistency for them. If they need medications, my client is not opposed to medications. She just says the idea that we're going to play this game of on, off, that's crazy. That's so risky. And so the idea that we need a parent who's willing to communicate and he isn't going to play the game of I'm going to hide whether or not the child's having a mental health issue because I think it's going to score me points in court. That's not the priority. The priority has to be the health and safety of these children. And my client's the only one who is willing to put the children first. Again, going back to the financial issues, because we are asking to modify some of those as part of the temporary orders. In this case, Mr. is already $7,000 and now more in arrears on spousal support. We're asking the court, there is a primary home. We're asking the court to order that to be sold. We do not believe that Mr. will comply. We just don't. Given the behavior, the fairly consistent behavior in this case, we can come here over and over on contempts. But as we do that, the house is going to get further and further behind. We're going to fall into foreclosure, and then we're selling it under a foreclosure or a short sale instead of selling it sort of volitionally. So we're asking the court to order it to be sold. It's logical. It has an incredibly high mortgage. The mortgage in this case is more than $2,300. That's very expensive for these two parties. It's logical to sell the home now. The estimates is that the home will net between $50,000 and $100,000. We would use those funds initially to catch up the arrears, to pay off the arrearage on the repossessed vehicle, pay off the other judgments that are in this case, and then provide some amount to each party from the amount that remains. And that's what we've proposed in our proposed order. So in this case, that's a very reasonable outcome. My client's currently in the family home. She's very willing to work to get it sold. We hope that we've proposed, I believe, some real estate agents. If parties can't agree, we can address that on presentation. But the idea that we would hold on to a home that's very expensive doesn't make a lot of sense. And especially when Mr. is sort of playing games with finances. It makes more sense to sell the home at this point. As far as child support, we're not re-arguing those numbers. Again, the court just set those 5 months ago. We don't believe there's been any substantial changes. No one has changed jobs. We did find a second job that Mr. participates in, but it's not a massive second job. It's just kind of a side gig is what I would call it. So we're asking that those numbers remain, but that the court eliminate any residential credit. As far as spousal support, the same spousal support should also remain. Again, there's no basis to modify spousal support. Everybody's finances are the same, and this is a long-term marriage where Mr. has an incredibly good job and my client is making essentially minimum wage type earnings while she's going to school. As far as fees, we are asking the court for an award of $5,000 for the motion for temporary orders, separate and apart from the contempt. There were efforts made to avoid this hearing. We shouldn't be here. We're here largely because Mr. Yanez just won't follow court orders. He is going to do what he wants to do. And so unfortunately, we're in a position where we then have to react and address those things for the health and safety of the children in this case. There's also a significant disparity of income between these two parties. Mr. makes $10,000 net before we're calculating in his second job. My client makes about $2,000. So he makes about 5 times what my client makes. It's very reasonable to award additional attorney fees. And again, those can be taken out of the proceeds of the house sale. So again, we're not necessarily even trying to get them out of Mr.'s pocket. We don't really believe he'll pay, but because the court can order the home to be sold, that is a way of accessing those funds. And so with that, we are asking the court to grant the relief we've requested, and we do have the guardian ad litem that can give the court input as well.
So, Mr. Yanis, this was set over in part to allow you an opportunity to respond. I've not received anything from you. Did you file a responsive declaration?
Yes, Your Honor, I did file a declaration
When?
on Friday.
Ms. Baldwin, did you receive a copy of that?
I did not
Office
receive
as well.
Ms. Yanis or Mr. Yanis, wait.
I did not receive a copy. I checked my email this morning. I checked ODYSSEY as well, and I don't have a hard copy. So I've checked every vehicle that I could check to see if there's any copies.
Your Honor, it was sent to a Miss Lisa, I'm checking the name here, Lisa, I apologize, just a moment.
Right.
Just a moment, please.
It's okay, I can verify. It went
Lisa
to my,
Romero.
it went to, so my staff did receive it. It looks like it went to spam because it's 105 pages that he filed, looks like on, let me ask when it was received.
Friday at 3:19 it was sent.
Okay, I don't have any reason to dispute that. So Friday at 3:19.
And I have not seen a copy of that either.
I would ask, it's not reasonable for him to have filed it Friday at 3:19. It's just not reasonable. In this case, we've set it over already for him. He, even at the last hearing, we were a month out. We're more than a month out at this point. It's just not reasonable to keep pushing it down the road when we have young people with some pretty significant issues.
Mr. Yanis, it's not timely under the local court rules. I'm not going to consider it. We have page limitations that I don't know what you have in 105 pages.
It wasn't 105, and the court, the court's clerk received it on Friday afternoon, and she made no comment about the number of pages. The
Well, that's not her
itself
job to comment on the 105 or whatever number. That's not her job to do it. It's my job as a judicial officer to say, one, it's not timely. I set this over to give you significant time to respond to all the allegations and timely respond, and it still wasn't done. So I won't be considering, Mr. Yanis, stop. So with that, I am not considering your affidavit or declaration that you filed. It's not in what is our system, ODYSSEY system. So I will not be considering it. Ms. Turnbull, anything you'd like to put in?
Not at this time.
So I've reviewed what the court is accepting as the documents that have been filed. Mr. Yanis was given more than enough time to properly respond, did not timely respond. So it is limited to the declarations that were filed by on behalf of Ms. Yanis, as well as any input of Ms. Turnbull. And so based on that, based on the files and record, the court does find the petitioner husband has failed to obey the orders of the court as stated by the respondent wife. He had every ability to comply with the orders in the past and now, and such failure has been willful and intentional. These are orders that must be followed. There isn't a choice. Do not pay maintenance. It is only going to damage your children. You will pay the back maintenance in full of $7,113.86 plus interest. There shall be a civil penalty of $1,000 to be added, plus $3,500 in attorney's fees and $85 in cost. As a result of the contempt, the failure to comply with the orders, the court has substantial concern for the well-being of the children, including your failure to follow the requirement for limited contact with Maggie Kennedy. You have blatantly disregarded this prohibition. Further, to take the children out of school to attend Maggie Kennedy's co-op when the children are already so far behind in their schooling is again harmful to your children. As well, to involve the children in the divorce is damaging to the children. You may think you're winning them over. The children have a right to love both parents and not be torn apart by adult matters. Therefore, the court is modifying the current parenting plan and adopting the proposed amended parenting plan. That in turn means child support shall be modified to reflect reduced overnights as set forth in the proposed child support worksheets of the respondent wife. In addition, the home will be sold. I'm adopting the temporary family law order with the modification in regard to the attorney's fees that I've ordered differently.
Your Honor, I do have a question for the court when you're ready.
It'll be a minute. I'm adopting the amended temporary parenting plan. If I didn't, I'm adopting the child support order and worksheets. All right, Mr. Yanis, you had a question?
Yes, Your Honor. I know, unfortunately, you didn't get a chance to look at the evidence that in relationship to the spousal support. I have already paid that. And so just from a semantic standpoint, am I being ordered to pay in addition to what I've already paid, or because it's all being garnished through DCS? So
If you've paid an amount, DCS will provide credit and then we can verify. I haven't seen that verification. So if and when it's paid, then we'll do the satisfaction.
to date, she's already received 16,000. So and I presented the evidence in my declaration, but I understand you didn't get to see that. So I just wanted to understand the semantics around, do I pay an additional 7,000 on top of what I've
It's
already
not
paid?
an additional. No, it's
Okay.
not an additional. You'll be credited for amounts you paid.
Okay, great. Thank you.
And then the only other issue, Mr. Yanez had referenced, not today and not in any materials I've seen today, but referenced using Our Family Wizard. We're happy to do that. I can just prepare a separate order, Mr. Yanez, that agrees to use Our Family Wizard. Or if Judge Hun wants to, she can just add that onto the last page of the parenting plan.
I'll just add it.
We're already using a Talking Parents app, and that's
Oh.
been working.
That's fine. We can add just Talking Parents. You're gonna just add that to the last page. Parents to communicate via Talking Parents. That is agreeable.
And Your Honor, there is one other question.
Oh, hold on.
Sure.
Ms. Baldwin, where are you talking about?
If you want to add it in, I think a good place to squeeze it in is page 9 of 10 of the parenting plan, right above right around line 17, where it says proposal. There's kind of a little empty space right there.
I'm sorry, what was the name of it? Family
Oh, Talking Parents is what they're using.
Talking. All right, I added in a line. Parents will continue to use Talking Parents to communicate regarding the children.
Perfect. Thank you.
All right, I've signed the orders.
Thank you, Your Honor.
Your Honor, one other question.
I can't now. I think Ms. Baldwin left. Oh, Ms. Baldwin, are you still there? Go ahead, Mr. Yanis.
So in my declaration, I did ask, I don't know what the process is, but I asked my previous attorney to go into mediation and wanted to know, is that a process that the court orders, or how do we get into mediation?
So I would talk to Ms. Baldwin and see if that's something that you can possibly do. I don't know if they're open to it or not. But why don't you reach out to Ms. Baldwin and ask her that?
All right, thank
Happy
you.
to address that.
Appreciate that, Your Honor.
Right, that concludes that matter. All right, with that, I will first call number 6 on the docket, 23-3-00278-08 Yanis and Yanis matter. That's Ms. Baldwin and Ryan Yanis.
That matter's ready. Mr. Yanis is present, as is the guardian ad litem. Guardian ad litem has filed her report timely in this manner. We're just under review to make sure that that report has been filed. Report is generally what the parties are currently doing. So at this time, I don't think there's anything that the court needs to do.
Okay, Mr. Yanis, anything from you?
No, I'm good.
Okay. All right, with that, that takes, and we do have Ms. Turnbull, anything from you?
No, I think my report summarizes my position.
Okay. All right, so with that, nothing further. That takes care of that matter.
Thank you.
The following day, on April 10th, 2024, they appeared on the trial setting docket to set a mandatory settlement conference. That MSC took place 3 months later on July 15th. It doesn't say if they came to an agreement or not, but my guess at this point would be no.
For 8 on the docket, it was 9-23-3-00278-08 Yanis v. Yanis.
That matter's ready.
We have Mr. Jones.
Yep, I'm here.
And Ms. Baldwin.
Thank you. And this is my motion to compel.
Okay. Counsel, go ahead.
Thank you. In cases like this, gamesmanship really matters. And when one party makes about $160,000 and one party makes about $25,000, how parties game discovery and weaponize discovery really matters. And I think that's the overall tenor of what you can see that's happening. Discovery was served about a year ago in 2023. The first Discovery Conference, or CR26I conference, was held in September of 2023 with answers agreed to be due by October of 2023. At that time, there's no reservations, everything would be provided. There was nothing that was a no, we won't provide that. So agreed, everything's going to be provided by October. Everything isn't provided by October. My office, and some things are just outright hidden and refused to be provided. My office then has to go through the expense and the trouble and the fees of subpoenaing documents that Mr. Yanis intentionally hid and intentionally kept from his discovery response. Those are his second job, essentially, that he was working at that time to prevent the full extent of his finances and full extent of his financial abilities from being known. Fast forward, we're still in a position where all of the materials haven't been provided. My office then sends a letter in July of 2024 that contains a complete list saying, hey, here's all the things that are still missing. Can we get this by agreement? Would you just provide? We're still now essentially approaching a year that discovery has been due and pending. No response. So we're just going to ignore the letter that's sent to us. We schedule a second CR26I. This happens in August. There's an agreement once again, and an agreement to the letter. We're going to provide everything that's in the letter. And so we agreed that all of that is going to be provided by September 5th. So nothing reserved, nothing held back, no exceptions. So we get to that date, what's provided, and once again, what we get is essentially 2 documents out of this entire list. My office then sends an email saying, hey, this is what we got. This is the list. Here's everything that's still missing. And again, we essentially get no response. I finally get a couple more documents trickle in after the fact, but again, no substantive, hey, these things don't exist, these things can't be provided. And we ultimately are in a position where we're filing our compel. This is very problematic. We have a year spent where we're trying to obtain some pretty basic documents. We've done 2 CR26Is where there's no statements of these things don't exist. I can't provide these things. No statements of effort. Mr. Yanez writes this declaration. He says, I can't get these documents. There's no statements on what efforts, if any, he has made to obtain the documents that are still due and owing at this point. He just says, I don't work there anymore, can't get them. He doesn't say, I've called that employer, I've reached out to that employer, the employer, here's a letter where they say they won't give them to me. So they're still within his possession and control. He's just basically saying, I don't work there, so I don't have to. But that's not what the rule says. The rule says is if it's within your possession and control. So again, we have Mr. Yanez really acting in bad faith and using the discovery process to really just leach out every dollar from his wife's possible attorney fees when he makes, not 4 times, but 5 times, 6 times what she makes in a year. And that's because there's just this huge disparity of income. One party can afford a lawyer, one party really can't. And so if you just string all of these things on, make it so that has to be all these letters, which are charged for, emails, which are charged for, conferences, which are charged for. And what you see in our materials is like, there's not 1 but 2 CR26Is, there's not 1 but 2 emails, there's a hard letter. There's a substantial effort to gain compliance. And the other side just says, we're just going to kind of ignore you. We're just going to ignore the process. We're not going to respond in good faith. And that's how we get to where we are now. So what I'm asking the court to do, I'm still asking the court to enter an order to compel. That would be to require that they provide everything that's left on the list. And if they're not providing it, to provide a written answer as to why and what efforts they have made to actually procure those documents instead of just, I don't have to, as an answer. Second, I'm asking the court for fees. I'm asking for $2,100 in fees and $100 in costs. The costs are for the costs of service of the subpoena that got us the Live Nation records, which were the records that Mr. Yanez initially withheld and didn't disclose in the first place. I think those are more than appropriate. Again, given essentially all of the effort that's gone into attempting to get Mr. Yanez to comply.
Mr. Jones?
Yeah, I think this is a good example of weaponized discovery from Ms. Baldwin. We're talking about 2023 pay stubs from Live Nation that Ms. Baldwin has already subpoenaed and received, apparently. We're talking about a second job that my client no longer has, where he earned approximately $3,000 per year. This is a very minuscule discovery issue that's in front of the court that Ms. Baldwin has used the nuclear option on trying to resolve. We provided her all the information that she's requested. We provided her my client's 2023 Live Nation W-2, which she requested. We provided his year-end pay stub for Live Nation, which gives her all the information that she needs to figure out this case. I think she wants every single pay stub, which apparently she already has through her Live Nation subpoena. We've given her every other document she's asked for in this motion, except for the 2023 tax returns, because he hasn't filed them because her client refuses to work with him to file the taxes. This is a frivolous motion to compel to run my client in front of the court to say he's a bad actor. All we want to do is resolve this case. All we've done is give them the documents they want. We can't be punished for documents and information that she already has, simply because she wants to file a motion to compel to check off another box of compliance. These people are not rich. This case has been pending for over a year. This needs to be resolved. They have everything they need to resolve this case. They have his income from 2023 for this second job that makes $3,000 a year. I'm kind of at a loss why we're here spending more money on the motion to compel when she has all the information, or she's already subpoenaed the information. Attorney fees are not appropriate. We've given her what she needs. Attorney fees are definitely not appropriate for the prior subpoenas. That can be decided at trial. These people need to figure it out and move on. And we've done the best that we can. I'm kind of at a loss, but I hope ask for this motion compel to be dismissed or denied. Again, I don't know at this point what Ms. Baldwin needs, and her ask to the court just to say produce it all or give us an explanation why. I don't know what she still needs, because she has the 2023 income, she has the bank statements, she has everything except for the 2023 tax return that has not been filed. So the court cannot order him to produce anything, because we don't know what she needs to produce at this point. Thank you.
Baldwin?
Thank you. So in this case, I said, well, Mr. Yanez doesn't have that job anymore. How would we know that? How would we know that if they don't state that? And again, we had not one, but two CR26Is where it stated, we'll produce it. Sure, we'll give you everything on this list, we'll produce it. And then it's disingenuous to say twice, we'll produce those things, and then come to court and say, oh, well, we didn't have it. But you told me twice in the CR26I that you would produce it. So you can't say you'll produce it and then say, oh, well, she should have known I didn't have it. How would I know? Because our 26I, the whole purpose of a 26I is to come together and have a discussion about, if you don't have something or something doesn't exist, is to say, hey, that thing doesn't exist. Or, hey, my client has to order that thing. It's going to take 8 weeks, or there's a cost to that. That's the purpose of a 26I. And so it's not sort of this game of saying, oh, I'll get it to you, and then later say, oh, I didn't even look into it before a conference, so I'm now going to say, because there's a motion, it doesn't exist. And he knew in advance of our conversation what was due and owing and what the questions were, because I had sent him a hard letter. So this was no gotcha. This was no surprise. There was a letter that listed it all out. So we knew exactly what we were going to discuss before we even had our second CR26I. So again, this idea that, oh, well, don't punish him now because, well, at the 11th hour, he's produced 90% of it. He can be absolutely held financially responsible for operating in bad faith. And that's what's happened here. They should be, and frankly, under the rules should be required, if they cannot produce something or something does not exist, they need to respond as such. This thing does not exist. My client does not have this. And his client statements of, oh, well, I can't obtain these. There's no showing of the effort that he's made or that he cannot obtain those things. My subpoena was issued in October, which means I don't have the remainder of that year. So again, issues there. So in this case, my request is appropriate. We are asking for the order to compel, and we are asking for the fees and the costs that are more than appropriate in this case when we've had a substantial showing of effort for compliance.
Again, I still don't know what she needs from the order to compel.
It's in the documents, counsel.
I don't know what documents wants, Your Honor. So
the court has reviewed this. Petitioner has failed to provide documents that counsel has agreed to provide to the respondents. Counsel last state pay stubs received within 2023 for Live Nation, 2023 W-2s, 1099s from Live Nation. And I get it. Counsel's saying, well, there's not much value. That's for Ms. Baldwin to look at. If your client worked at Live Nation, then he either needs to get them and provide them or make the statement that and show proof that he can't get them. As far as the tax return, it sounds like that's something that you have said that you can't provide. And then the most recent pay stubs from Live Nation, it sounds like that's something, again, after 23 can't provide. But the process is there, process has not been followed. And petitioner appears to be dragging his feet to do something that should be simple and straightforward. So the requests appear to be relevant and agreed to be provided. The respondent has failed to provide, the petitioner has failed to provide the information as made pursuant to the CR 26I agreement. Therefore, the court orders the documents to be provided within 14 days of today's date. For the necessity of having to bring this motion, the court does order the requested attorney's fees as they are reasonable and the fees are appropriate for the rates in this area. That's $2,100 within 30 days of today's date. The court will review this matter in 2 weeks on October 22nd and will consider additional relief.
I believe you have an order there before you, or we can do one in 2 weeks. Either's fine.
I do have an order.
I'd object to the order. It's got language about credibility, et cetera, that's not relevant.
So counsel, I would agree. I just want a straightforward order. This is a straightforward procedure issue, nothing more.
Okay.
So if you would remove that and resubmit an order.
Oh, the only line is he's talking about is on page 2, and it just says the court finds the objections to be not credible.
I'll
That's
just
an
line
appropriate
that out.
Yeah, that's fine.
I think there's 7 days in that order, so the 14 needs to be, the 7 days needs to be changed to 14 days, I think.
And that's fine too. That's just below that.
Okay, change the 7 to 14. So, Mr. Jones, do you agree as to form at this point?
Yeah. And I would just add for the record that my client did submit his letter of resignation for Live Nation from 2023, so they knew he was not working there in 2024.
Okay, I'll sign the order.
Great, thank you.
They had a compliance hearing the following week on October 22nd, but unfortunately, I was ill that day and unable to get the stream. I assume that Attorney Baldwin was satisfied with Dad's compliance in sending the remaining documents, since they did not schedule any more compliance hearings, but left it so she would renote the matter if more problems arose. She did sign the $2,100 judgment for attorney fees, as well as another judgment for $111.57, which I assume is a civil penalty and some interest. They had 2 trial assignment hearings the following month in November, but for some reason they were both continued. I don't have copies of those hearings, but I do have the 3rd one where they finally set a trial date.
Number 5, Yanez v. Yanez, 23-300-27808. Looks like I have Ms. Baldwin. And do I have Mr. Jones?
Yes, I'm here. Cool, Jones
Okay.
is here.
So we're looking for 2 days, and this is for trial. Probably realistic. I'd like to be in civil priority week no sooner than May.
I think that will not be a problem if we're looking for civil priority week. Mr. Jones, is it okay if we start looking at our civil priority weeks? It's going to be a bit out there.
That's all right.
Okay. And 2-day non-jury, correct?
Correct.
Okay.
We could either do civil priority the week of May 5th, or else it would be the week of July 7th.
May 5th sounds better. Let's do that.
That works with me.
So readiness would be April 29th at 11:30.
All right. Very good.
All right.
Thank you.
Yep,
Thank you.
thank you both.
5 months later, at the end of April 2025, they had their readiness hearing, and I was pleasantly surprised to see that they were actually ready to go to trial. No cancellations or continuances. Odyssey says that they had their 2-day trial on May 8th, 2025, but I also noticed something interesting. It also says on that same date that the parties reached an agreement at a settlement conference hearing. I don't know if they decided to have a settlement conference instead of a trial, or if they were still negotiating and came to an agreement before the trial was over, but however it was decided, it looks like the parties negotiated a settlement instead of leaving it entirely up to the judge. The judge entered all the usual final orders, including a decree of dissolution, a final parenting plan, and the support worksheets. These final orders also included a judgment. Dad was ordered to pay $25,000 in what I'm guessing is attorney fees. While I don't know for sure, that would be my first guess. I would assume he would be ordered to pay a portion of her attorney fees since they had such a long-term marriage and such a big discrepancy in income levels. There was a final hearing in this case a month later on June 3rd, 2025, and it was about the GAL fees. It appears that Mom may have paid the whole GAL fee and Dad must now reimburse her, because Dad is supposed to pay Atty Baldwin the GAL fees and not Amy directly. I do recall a 4-month delay getting the GAL started, and that was related to Dad setting up a payment plan with Amy, so I assume Mom ended up paying the whole thing up front so they could get on with it. That was the final entry in Odyssey. It's a bummer that we don't get to know any of the details of their settlement, but we do know that Atty Baldwin went into that settlement conference with the upper hand, in my opinion, after the contempt and the change in the parenting plan to Dad just having weekends. I'd be shocked to discover that Mom agreed to any weekday overnights after all the problems with their schooling. We didn't get to hear what Amy thinks, but she also didn't protest against anything Atty Baldwin was claiming. I know that protecting those children would be her top priority, so I trust her to fight for what's best. I hope those children get the help they need, especially with their schooling and mental health. It sounds like they should all be in therapy. Thanks so much for watching.